think I've been seeing a lot of questions about whether, excuse me, everybody can hear, so I thought I'd get us started. My name is Heidi Sharp. I'm the current treasurer of the State Bar of Michigan Labor and Employment Section, and I tried to do the best we could to put together our new virtual presentation for today. We've got a really great slate of speakers set up, some of them who can be live with us virtually, and some of them who couldn't be, but they took the time to tape some really great updates for you. So I'd like to welcome everybody. I see we have almost 200 participants, which makes me really excited because in years past, we've only had about 100 people in the room. So this really gives us a chance to have everybody on board and get a lot of more information, everybody. I see Michelle has joined us, our section chair, so I'll let her take over with the welcoming everybody, and then we'll get started with our panel.
Thank you, Heidi, so much. So good afternoon, everyone. Welcome to our first ever virtual meeting, right? So thank you so much for joining us today. The council was determined that COVID would not stop us from getting together as we normally do every January to learn about the latest developments in labor and employment law, elect new council members, acknowledge the service of our outgoing members, and perhaps most importantly, honor one of our own via the presentation of the Distinguished Service Award. So there's no question that this is a different way to gather, right? We all miss the ability to socialize and interact with one another in person, but we are all here, and there's a lot to be said for that. So sit back and enjoy the truly wonderful program that we've put together for you. Heidi Sharp has just done an amazing job to make sure that everything came together today. Our first speaker this afternoon is Amy Dravecki, and Amy is not able to be with us in person, but she was gracious enough to record her presentation for all of us. Amy is a partner at Barnes & Thornburg and counsels employers throughout the country on traditional labor relations and employment law matters. She focuses on National Labor Relations Board proceedings, union organizing campaigns, and NLRB elections, arbitrations, collective bargaining, and other contract negotiations and employment discrimination issues. Amy will be providing us with an NLRB update, so everyone enjoy. So it looks like we're having some technical difficulties, clearly. It looks like they're trying to work on it. So again, just please be patient with us. I would ask that just if everyone who hasn't already done so, please mute your mics and also turn off your video if you are not presenting, please. Okay, here we go. Thank you all for being patient. I'm going to be quiet now.
Always easier said than done. And again, as usual, we have a lot to talk about in the next 30 minutes, so bear with me. Today, we're going to talk about a packed agenda, union organizing, the current makeup of the NLRB, which we have some changes since this presentation was prepared that just occurred yesterday. Today is January 21st, the day after President Biden was inaugurated. And so we've already seen some change in the makeup of the NLRB. We're going to talk about the significant NLRB decisions from 2020 and some other significant NLRB developments. Finally, we're going to end with talking about what to expect expect from the Biden National Labor Relations Board. And this is going to be significant as we've talked about the last couple of years, what's happened during the Trump board. And I've said, watch out for this, look for this. Well, now that's what we're going to be doing with the Biden board. So again, we're in for quite a lot today and going forward, I think the next 4 years. So as far as union organizing, there were less, as expected, there were less elections that occurred during the pandemic than previous years. Only about just under 1,000 total, whereas in previous years it's been about 1,500. But the pandemic did not affect the union's win rate. What we saw is that unions were winning about 72% of the mail ballot elections, 70% of the manual elections, the in-person elections. And that's pretty consistent with the union's win rate over the past 5 years prior. So having the pandemic did not affect union success. What it did mean is that more of the elections were conducted by mail ballot. And I think that as practitioners, we expected that we would see a higher win rate when unions went to a mail ballot, but it was only slightly higher. So I expect that we're going to see, as soon as the pandemic subsides, as soon as more people are vaccinated, more people are back to work, we're going to see a whole host of union activity. And these election statistics will look very different at the end of 2020 with a lot more union elections. And I predict, based on the changes we're going to talk about, a lot more union wins. So the current makeup of the NLRB, and I put this in quotes even before what happened yesterday, the current NLRB has 3 Republicans and 1 Democrat currently in the position, with 1 vacant position. And you see here, and this is pretty typical of NLRB makeup during whatever president is in office. Typically what we see is when we have a Republican president, there's 3 Republicans on the board and 2 Democrats, and a Democratic president, we will see 3 Democrats and 2 Republicans. So here we see that there's just right now 1 Democrat, Lauren McFerrin, who, by the way, just yesterday on Inauguration Day was elected to be the chairman of the NLRB, taking over from John Ring, who served as chairman under President Trump of the NLRB. So Lauren McFerrin now will be the chairman. And we also see that there's a vacant position that could be filled at any time. There's lots of talk about the fact that President Biden will likely do this very quickly, fill that term. And then there's a Republican seat, Bill Emanuel, whose term expires in August of this year. And we expect that obviously that will be a Democrat position as well. So Democrats could take control, not only just the chairman position, we could take control of the NLRB as early as August of this year with a 3-seat majority. You also see here that I have on here the current makeup of the General Counsel's office, that the General Counsel was Peter Robb, and his term was scheduled to expire in November of 2021. However, update to the slide, just last night on Inauguration Day, President Biden fired Peter Robb as the General Counsel of the NLRB. That's a really unprecedented step. It was very much encouraged by a number of unions who felt that that General Counsel Robb did not take care of employees' rights. And therefore, we expect to see this position filled very quickly too, with somebody who is obviously very pro-labor and very pro-union. And I think that's going to dramatically shift the focus of the board, because as we know, that the General Counsel is the chief prosecutor for the National Labor Relations Board. So he or she will determine what cases to prosecute, what complaints to issue, and what issues are going to be at the forefront of cases going before the board. And so I think that, getting rid of, firing Mr. Robb and getting a new General Counsel who's probably going to be much more pro-union, pro-labor, is going to dramatically change the direction of the NLRB and what their focus is going to be with cases going forward. I want to talk about just briefly some significant 2020 NLRB decisions. There were fewer this past year than there had been in the last 3 years that we talked about. Still very significant decisions, although it'll be interesting to see with the current administration whether these are the law of the land for long. So first I want to talk about union solicitation. And it has always been in the past something that as practitioners, we looked at solicitation as encouraging support for the union, getting people to sign union cards. And it's been lawful to have policies to say, you can't engage in solicitation on work time. That's typically been the policies that employers have had that, as someone who represents employers, that we recommended that this would be a lawful policy. You can't prohibit people from talking about it in work areas if they're not working. You certainly can't prohibit it, off-site, can't prohibit it in the parking lot, can't prohibit it in the lunchroom if they're not working. But on work time, you can prohibit them from getting cards signed during that time period for the union. In this particular case, what happened was that after finishing her last, her shift, a game dealer approached an on-duty, someone who was on duty, security guard, and had a 3-minute conversation encouraging him to vote for the union, not asking him to sign anything, but saying basically, here's why I think you should vote for the union. During that time period, there was a disruption of work because several guests were unable to talk to the guard. And the employer then disciplined the employee for violating the no solicitation policy by talking to someone who was on duty about the union. And in the past, as I said, it was only an interruption where an employee was asking a coworker to sign a union's authorization card. We couldn't prohibit employees from talking about the union. I mean, if you think about this, we always said to employers, look, if you allow people to talk about the Chiefs game on Sunday during work, then you have to allow them to talk about the union as well. The card solicitation was treated differently, and the Trump NLRB rejected this interruption standard and said, you have to balance the rights of employees to organize against the employer's right to maintain discipline. And the NLRB said, we're going to interpret that the solicitation for or against a union also encompasses the act of encouraging employees to vote for or against union representation. And therefore, employers can ban on the clock, or under this Wynn Las Vegas case, the employers can ban on the clock talk about union representation. Even if, by the way, they allow on the clock talk about other non-work subjects. And so this is, I think, a very significant departure from previous law, but also significant to the extent that employers now, at least under this case law, have much more right to control what their employees are talking about, and much more right to control people talking about the union on work time. Now, it is important to remember that employers cannot ban solicitation talk during all working hours, because if it's a paid break, employees can talk about it on the break, just during work time when they're actually supposed to be performing work. And so we need to make sure that we always talk about that distinction as well. Now, how long this case will be the law of the land with the change in the makeup of the board, I think this is probably going to be short-lived, but in the meantime, certainly employers have a right to have this rule. In addition, I want to talk about the Securitas case. And this case arose, if you remember last January when we met, that the Trump NLRB had overturned the previous case of Banner Estrella, which had held that employers could not prohibit employees from talking about confidential workplace investigations. So you couldn't have an across-the-board rule that said during investigations you cannot talk about what's going on. And that in 2018, we talked about it last year at our January meeting. And this is just an extension of that case. So in Securitas, the facts were an employee witnessed an argument between a coworker and a supervisor, and where the person witnessed the coworker making racial discrimination complaint against the supervisor. In response, Securitas conducted an investigation and interviewed the employee who was the only witness. And during that interview, the Human Resources instructed the employee not to discuss what he had seen or this investigation with anyone else. And after that, the employee who had witnessed this sent some questions to HR, and HR said, hey, you're barred from talking about this during the time of the investigation in any circumstances. And after the investigation, if anyone starts conversing about it, those conversations become, and if those conversations become a distraction, you could face disciplinary action. So this was obviously prior to Banner Estrella being overturned. So an ALJ said, hey, this is unlawful because you can have a confidentiality mandate as determined in NLRA. The NLRB, however, disagreed and explained that confidentiality mandate during confidentiality mandates during an open investigation are lawful because the justifications outweigh their potential adverse effect on employees' exercise of their protected rights. So basically, it's more important for an employer to be able to keep a confidential investigation closed and control it than it is. That's more important than employees being able to talk about what's actually going on in the investigation, how it might affect their rights. And the board also said that this rule that Securitas had was lawful because it did not extend beyond the duration of the investigation. The board clarified that post-investigation discussions, while not banned, can remain subject to an employee's work rules for being disrupted, inappropriate, or abusive workplace investigations. So in short, you can implement, and employers can implement confidentiality rules in open investigations to encourage employees to come forward with complaints. And that they're presumptively lawful if there's a justification to prevent workplace disruption. And the employer may, there's a typo here actually, it should say the employer may not limit an employer's ability, or an employer may limit, the NLRA may limit an employer's ability to require confidentiality after the investigation without proper justification. So again, you can actually limit talk about the investigation during, while the investigation is pending. You may not be able to do so after the investigation unless you can show that the reason for doing so is to prohibit disruption in the workplace. Again, whether this will become, whether this will stay the law for long, or whether the board will return to its previous standard in NLRA, which said, you can't prohibit employees from talking about confidential investigations, it remains to be seen. The third and very significant case that I want to talk about is the GM case. And by the way, this was a case that, and last January, I said, we need to watch out for what's going to happen. And it was actually decided in July of 2020. And we talked about this because this was very significant in the sense that the fact that it was pending would and did overrule many prior NLRB cases that had found that employees who had been engaged in protected concerted activity, complaining about their wages, hours, and working conditions, that they didn't lose their protection of the act, even when their conduct became offensive, abusive, or derogatory. And the best example I gave to you last January was the Cooper Tire case. The Cooper Tire was a case where an employee on the picket line, so engaged in protected concerted activity and the ability to picket, to engage in a strike, had made racial slurs about the employees who were crossing over the picket line. And the Cooper Tire had fired that person, saying, although you might have been engaged in protected concerted activity, picketing, you lost that protection when you violated our harassment and discrimination policy. And the board said, no, necessarily employees who are engaged in protected concerted activity get upset and they may say things they shouldn't, but they don't lose their protection just because they take it over the line. And that was something that as employers, we found this, it put us in a rock between a rock and a hard place, because how could we enforce our discrimination harassment policies if as long as an employee was engaged in protected concerted activity in complaining or protesting, we couldn't do so? Well, GM put an end to that. GM basically said employees engaged in abusive conduct in the course of protected concerted activities are not automatically shielded from discipline. So in the case where general counsel of the NLRB can show that, yes, the employee was engaged in protected concerted activity, complaining about wages, hours, and working conditions. Yes, the employer knew of that activity. And yes, the employer was motivated to take some kind of negative action against the person by the knowledge of that protected concerted activity. The company can still succeed in the charge if it can show that it would have taken the same action anyway. So if the employer can show that, when somebody violates this work rule in this manner, the action we take is discharge. So even if the person is engaged in protected concerted activity, if they are offensive, if they are abusive, if they are, racially discriminatory, and we can show that even in the absence of that protected concerted activity, this is how we disciplined it, then the employer may be able, the employee is not shielded from discipline, and the discipline can be upheld. Now, again, a significant case because it overruled many NLRB cases that had held to the contrary, and it put an end to concern that the NLRB was pitted against Title VII, and how could you enforce both of them? It'll remain to be seen, again, with the new NLRB, with the change of administration, how long this policy and this case will stand. I want to talk about a couple of other significant NLRB developments in 2020. One is that there was finally some guidance on who a joint employer is, at least for now. So this goes back to 2015 Browning-Ferris decision, which we've talked about the last couple of years. And in that case, the board changed its 50-year precedent to say, you can be a joint employer even if you don't have direct control over the other entity's employees, but where you have either reserved or indirect control. And the NLRB, there were a couple of attempts to overturn Browning-Ferris with case law. And finally, in September of 2018, the NLRB proposed that they were going to address this by rulemaking to restore the prior standard and to hold that that a joint employer must actually exercise authority directly over the employees. However, in the meantime, the DC Circuit affirmed the prior 2015 decision, but found that it was misapplied, so sent it back to the board. And finally, what happened in February of this past year, right after we met, is that the NLRB issued its final joint employer rule. It became effective on April 27th. And this reverted to the prior standard, prior to Browning-Ferris, that said an entity may be considered a joint employer of a separate employer's employees only if the two share or co-determine the employee's essential terms and conditions of employment, which are exclusively defined as wages, benefits, hours of work, hiring, etc. So it's not enough that you have reserved or indirect control to be a joint employer. Rather, you have to, the board would have to show, or the prosecutor would have to show, the general counsel would have to show that you actually had control over the other employer's employees with respect to these essential terms and conditions of employment. So, so this dramatically limits who can be considered a joint employer. However, again, whether this will withstand the new administration will remain to be seen, and whether, in fact, this rule will even continue. The other thing that happened in 2020, and this was due to the pandemic, is that former General Counsel Peter Robb, came out on the side of employers with respect to bargaining in emergencies. And basically, there were a number of situations where employers, especially in healthcare, well, all essential workers, frankly, said, gosh, we've got to make these rapid changes in working conditions or wages or benefits due to the pandemic. And, we don't want to be held up by our obligation to bargain with the union. And so Peter Robb issued this memorandum and also decided a number of cases with respect to this. And the bottom line was that the NLRB was really showing some leeway here to employers and saying, look, if you can show that you need to make a quick, decisive action, you can go ahead and do that, and then you can bargain with the union after that. You have to show a legitimate reason why you couldn't wait to bargain with the union and to get a decision before you acted. And then, of course, although you already made the decision, not only will you have to show why you had to make the decision at the time you did, but you always have to bargain over the effects of that decision. And this was really a substantial departure from bargaining obligations and recognizing that employers during the pandemic really had to act quickly and to make changes. Now, whether the current administration, the Biden administration, and the Biden NLRB and the new Biden General Counsel will continue to give such deference to employers to make these decisions without bargaining with the union, I don't think that's going to happen. So we'll have to keep a careful watch on that. Another significant development in 2020 was that the NLRB had proposed and made effective a number of changes to the 2015 election rules. And if you remember us talking about this, in 2015, the board made a number of changes to make it faster for a union to get to an election. And significantly, it required that most challenges to an election, to the units that proposed by the union, would have to be dealt with after the election instead of before. And so as a result of that, prior to the 2015 rules, typically when a union filed a petition for an election, an employer had 42 days between the petition and the date of the election for the vote. So you had 42 days basically as an employer to campaign to your employees. And these 2015 rules really effectively sped along that process. So what we saw is that most elections were occurring anywhere from 9 to 25 days, with 25 days really being the max in most regions. So unions were getting to elections quicker, and as a result of that, the union win rate did go up, although slightly. Well, almost immediately after those were passed, of course, the administration changed, and the Trump NLRB took it upon themselves to say, we need to modify this. It's just not giving employers enough time to communicate with their employees about the campaign. And so there were a number of modifications made effective June 1st, 2020. And specifically, it gave the employer a little bit more time to get to a hearing. It changed the timelines for when it had to post this notice of election. It reinstated the opportunity to file post-hearing briefs. It reinstated some discretion to the regional director on when the timing of the notice or when the timing of an election should be held. It allowed for certain changes in what could be challenged before, and so that you could actually decide unit issues before instead of waiting until afterwards. It allowed where there was where a request for review was pending to impound the ballots. So to go ahead with the election and impound the ballots instead of waiting till the request for review is decided. So a number of changes to make it to give employers a little bit more time and a little more control over the process. A number of the modifications, though, that were part of the changes in the rules were actually delayed pending appeal. And so these were the really significant issues. In May, these issues were enjoined and giving the parties the right to litigate over all voter eligibility issues. Instructing the regional director will not schedule an election before the 20th day, so making the 20th day the earliest, the regional, that was enjoined. Increasing the time in which the employer has to provide the voter list from 5 days to 5 days instead of 2. Limiting a party selection of election observers to individuals who are in the unit, and instructing that regional directors would no longer issue certifications following elections if a request for review is pending. So these were the things that were enjoined and did not become part of the rule modifications. Now, as we'll talk about in just a minute, one of the items I believe on the Biden NLRB agenda will be to completely get rid of these modifications that were passed in June and go back to the 2015 rules as they existed. Another development that came out in 2020 was former General Counsel Peter Robb's guidance on neutrality and taking the position that agreements between an employer and a union to organize subsequent facilities, subsequent sites may not be lawful, that they may not give employees the right to decide whether they want a union or not, which is part of the statute, right? Employees have the right to choose to join or form a union or to refrain from doing so. And so Rob issued guidance back in September saying, neutrality agreements that don't give employees the right to decide this may not, in fact, be lawful. Now, this was just something that was never followed through on, simply his opinion. But I think that we're going to see a very different view from the next general counsel and from the next board. So just a few more minutes here that I have with you. And we should be looking, and I always leave our sessions like this to say, what are we looking for the next year? So what will likely be the agenda for the Biden board? Well, there's lots on it. So first of all, we expect to see a return to specialty healthcare, which held that unions can organize micro units. They don't have to organize the most appropriate unit. They can organize whatever unit they think is appropriate, and they can pick off the smallest groups or smallest job classifications where the employer might be most vulnerable to organize. And then the burden will be back on the employer to show that no, these other people must be included, and the other individuals who are left out have an overwhelming community of interest with those that are included. So we might see those micro units again. We can expect to see a return to purple communications, which gave employees email access to employers' email systems for purposes of communicating protected concerted activity or for purposes of communicating union activity. We expect to see a return to the pre-Boeing standard for evaluating workplace rules. We spent a lot of time the last 2 years talking about Boeing and talking about the fact that certain work rules now in an employer's handbook were per se lawful. So for example, you can have civility policies under the Boeing standard. You can have policies that prohibit recording of communications. You can have policies that address confidentiality of your information, that those policies are per se lawful, and that you balance, with respect to other rules, you balance the employer's right to control its workplace against the employee's rights to engage in protected concerted activity. Well, as you probably remember, the standard prior to Boeing was the standard established in 2004 in Lutheran Heritage, which said that we have to evaluate rules that could a reasonable person read this rule as restricting my ability to engage in protected concerted activity, even if it's neutral on its face. And that led to a lot of rules, especially under the Obama board, being considered to be unlawfully overbroad, even where the employer did not intend to enforce them against union activity or protected concerted activity. And it was, as somebody who represents employers, it was very frustrating that what we consider to be a neutral rule could be considered to be unlawfully overbroad. And unfortunately, I think that we're going back to a period where employers' rules are going to be scrutinized again. And so heads up to any employers' counsel out there that you may want to take a look at your clients' handbooks in the next year or so as the board makeup changes. We expect to return to the pre-Johnson Control standard for when you can withdraw recognition from a union, typically when the contract expires, but Johnson Control had moved that date back to prior to contract expiration. Return to the 2015 election rules to make it faster to get to an election. We just talked about that. Return to the pre-MVP transportation case, which we talked about last year, for evaluating contract coverage cases. Again, to basically require that a management rights clause specifically say that the employer has this right. It can't just be construed that, for example, if you say, we have the right to make disciplinary rules, that includes the right to make changes to your attendance policy unilaterally. Whereas prior to MVP transportation, it was a situation where, the board looked at, did this cover this, or is this something you had to bargain with the union? We returned to the Brown and Ferris joint employer standard, which will make it more expansive to be a joint employer. All you have to show is indirect control. We talked about that. We expect that the board will limit the definition of independent contractors so that more independent contractors can organize, allow graduate students to organize, broaden the lawfulness of secondary activities. So again, if you don't have a dispute with an employer or a dispute with a union, but you're using a contractor on your site who does, unions are restricted right now on what they can do against you to protest the right that you're using this non-union contractor. We expect that there will be a broadening of what unions can do in that situation. Expanding the definition of protected concerted activity. There was a lot of talk or a lot of decisions during the Obama board about, is this a personal gripe or is this something that is intended to induce group action? That really got limited under the Trump board. We expect that to be expanded again. undo the 2020 rules regarding blocking charges and voluntary recognition that the board passed, eliminate the right of employers to stop dues deduction post-contract, which they currently have, grant Weingarten rights for non-union employees. So just going back in history here, there was a period between 2001 and 2004 where where non-union employees had the right to a coworker of their choice if they were being asked to participate in an investigatory interview that could lead to discipline. That right only existed for non-union employees between 2001 and 2004. It never came back, but we know it's on, we think it's on the agenda for our Biden board. And then return to Banner Estrella, which we talked about with respect to prohibiting employers from restricting employees from talking about confidential workplace investigation policies. So a lot on the agenda for the next 2 years, a lot to talk about, a lot we'll be looking to see what happens, and we'll be talking about this hopefully in person next January, what's happened. So I'm sorry that I wasn't with you in person or live, and so if you have any questions about anything I've talked about today, please do not hesitate to email me. I'm happy to answer your questions. And again, it's always an honor and privilege to be asked to speak at this meeting. I'm just sorry I can't see you in person and hope to see you next year. Thanks so much.
Again, I have the privilege of introducing our next speaker. Kevin Carlson will be giving us updates on the state and federal laws regarding disability rights. Kevin is at Pitt, McGee, Palmer, Benani, and Rivers, and he previously was part of the federal pro bono clinic, providing a lot of help to pro bono individuals who needed that. He represents plaintiffs in employment discrimination and civil rights cases, and I see he's ready to go, so take it away, Kevin.
Thanks, Heidi. Following up on what Amy said, it really is an honor to be allowed to present today, and it's unfortunate that we can't all get together. It's a highlight of sort of the cold days of winter to get together with everyone at this midwinter meeting every year, and I'm sorry we're missing out on it in the traditional sense. I'm going to share my screen, which just has the same materials that went out in the packet. And we'll start with Supreme Court cases. I know this is part of the EEO update, this case is that Maria is going to do in a little bit. So I won't spend a whole lot of time on Our Lady of Guadalupe School versus Morrissey Baru. This case is about the ministerial exception to federal employment discrimination statutes. This case confirms sort of what we already knew from the court's 2012 decision in Hosanna Tabor, that the exception is very broad. It does not mean, at least the court says it does not mean a blanket immunity for religious employers, but it does mean that employees will have to make a threshold showing, excuse me, that their employment and the nature of their job does not relate or does not touch upon the religious and ministerial aspects of the institution. Otherwise, judicial review is basically completely barred. Two other important takeaways from the case in terms of applying the ministerial exception is that according to the court, the employer can't simply label all employees as minister and then be granted the exception. They have to show that what the employee actually does in terms of their job duties and responsibilities is related to the ministerial aspects of the institution itself. The next case that I want to highlight is a Sixth Circuit case called Chenkva versus Ascena Retail Group. This case is a red flag for ADA plaintiffs when the employer is clearly doing more work than the employee in terms of the interactive process to try and determine the need for a reasonable accommodation. And that's a common red flag that we'll see in the Sixth Circuit cases and the state law cases as well. It's also a red flag for plaintiffs that we'll see in other cases where the employee resigns their employment before the interactive process has been completed or where it appears that the interactive process is one-sided and the employer is reaching out, but the employee is somewhat non-responsive to the employer's request for information or efforts to accommodate. This is in contrast with the Fisher versus Nissan case that we're going to see later in the presentation that's also in the materials. It's consistent with the McDonald versus UAW GM Health Center case that we're also going to be seeing on those 2 points. This case also involves the presumption that has existed since the EEOC versus Ford Motor Company case several years ago, that on-site presence at the job is presumptively an essential job requirement for all jobs. And you should flag that issue for when we talk about when an employee is qualified for coverage under the Michigan Persons with Disabilities Civil Rights Act. There's a question unanswered in this case, in the Sixth Circuit cases of the year, as to what our experience in the last 10 to 12 months with the COVID-19 pandemic is going to do for cases involving work from home accommodations. Work from home accommodations are much more likely to be found reasonable when the evidence in the record shows that the employee has worked from home in the past, or that comparable employees in the workplace have worked from home without any undue hardship. And I suspect that when people return to on-site work after the pandemic clears up, there's going to be some cases where the employee uses their work from home, their success working from home during the pandemic as a demonstration for why the work from home accommodation that they're asking for is reasonable. And the employee employer is going to have to demonstrate why it's an undue hardship if it's been working so long under the pandemic. There's a background issue here, which is sort of unrelated to ADA, about what the standard for showing constructive discharge is going to be in the Sixth Circuit moving forward. The Sixth Circuit says in dicta that it's not going to decide whether the employer has to have a subjective intent to force the employee to quit. And they cite the Supreme Court's decision in Green versus Brennan as saying that it might require a change of Sixth Circuit case law on that issue. So in Green versus Brennan, the Supreme Court made it very clear, and the quote from the holding is, quote, "We do not require an employee to come forward with proof that not only was the discrimination so bad that he had to quit, but also that his quitting was employer's plan all along." So under Supreme Court precedent, in Title VII cases, the employee has to show that it was reasonably foreseeable that resignation would be the consequence of the employer's conduct. In the Sixth Circuit, this panel is suggesting that the employee has to show some subjective intent. And again, that's an open question, but it seems likely that the Sixth Circuit may redecide or reformulate its intent requirement for constructive discharge cases, and it's mentioned here. It's probably worth keeping an eye on that issue. In Darby versus Childvine, the Sixth Circuit held that the plaintiff's diagnosis of abnormal precancerous cells was sufficient to allege disability under the ADA at the 12B6 stage, because there was medical evidence in the record that the cells had actually begun the process of changing from normal cell composition to cancerous cell composition. It cautioned that there might be a problem for the plaintiff at the summary judgment stage, and that she would probably need medical expert opinion testimony to establish a fact question for the jury on whether the abnormality in the cells was a qualifying disability under the ADA. Again, a 12B6 case where the court says, the outcome might be different if the expert evidence does not show actual changes and mutations to the ways that the cells have grown, even if it hasn't developed into full-blown cancer. The next case to flag is Harrison versus Suave Enterprises, which is a case where the plaintiff managed a salvage yard for the defendant. It's one of these businesses where they have a gated and fenced in salvage yard with old cars and used car parts, and they charge people like $2 or $3 to get in, and then you can harvest whatever parts you want off of these old automobiles. And she used an electric cart to get around, and she used a telescoping mirror to look underneath the bodies of the car to inspect them if the fluids had been drained out before people came in and tore them up. The Sixth Circuit reversed the district court's grant of summary judgment to Suave because it found that she did not, the plaintiff did not have to show a specific limitation on the amount of kneeling or lifting or walking that she could do. It was enough that the record showed that she had difficulty doing those activities because of her pre-existing knee injury, which is a torn ACL and meniscus that had been partially repaired after surgery. I would just say that this case is probably a must-read because it really demonstrates how the court is going to analyze the facts of ADA actual and regarded as disability claims. It has two relatively new Sixth Circuit judges, Judges Bush and Murphy, on the panel, and it's worth reading for that reason. A note, sorry, that reminds me, a note on the materials. I included in all cases, the list of judges that decided these cases because I think it's helpful when, if you have a case that's going to go to the Michigan Court of Appeals or the Sixth Circuit or even in the federal district court, to have an idea of how each judge looks at these cases individually and also collectively as a circuit or as a court. In the write-up, the judge listed first is the judge that wrote the opinion, unless it's per curiam, in which case it's not indicated. McDonald versus UAW GM Center for Human Resources is a recent Sixth Circuit decision where the employee quit her job because she did not like the accommodations that were proposed by the employer. And I flag it because, the idea that an employee can't, the idea that an employee does deserve a reasonable accommodation, but is not entitled to their preferred accommodation is old news. But this case demonstrates a newer fact pattern like the Chenkva case that we looked at earlier, where it appears from the record that the employer was dutiful in how it engaged in the interactive process and attempting to accommodate and propose accommodations, and the employee is held responsible based on the evidence for walking away from the interactive process. That's a bad fact pattern for plaintiffs in ADA cases. And in terms of case selection and case development, it should be a red flag with how the employee and the employer have upheld their relative responsibilities within the interactive process. The big takeaway from Thompson versus Fresh Products LLC is that in the Sixth Circuit, contractual agreements to arbitrate employment claims brought under federal employment discrimination statutes are unenforceable to the extent that they attempt to shorten the filing time from 300 days to 180 days. This case happens to involve Title VII ADEA and ADA claims. It's the second year in a row where The Sixth Circuit in a published decision has held that these agreements are not enforceable as to federal statutory claims involving mandatory EEOC filing and exhaustion requirements. The mandatory arbitration, not mandatory arbitration, the shortened statute of limitations period was upheld in this case as to the Ohio statutory claims where there was no similar enforcement mechanism or administrative filing requirement as there is under federal law. The facts of the underlying substantive claims in Thompson are noteworthy only for the court's conclusion that the plaintiff's own testimony about her limitations was enough to establish a fact question as to whether she was disabled. She did not need medical evidence or additional evidence beyond her own testimony regarding the extent of the disability and its impact on major life activities. Gerhardt versus DuPont is a very sad case when you read the fact pattern. The employee worked for DuPont for many, many years, and he had a very unique position which required him to walk inside of these large ovens that ran, at 140, 150 degrees inside, even when they were not activated. And he had severe heart problems, a heart attack, triple bypass surgery, and couldn't, safely wear the heavy PPE and get inside and do the strenuous work of cleaning out the inside of these ovens. And it's an example of the rare case when the court is going to find that an ADA plaintiff is unqualified for the position. And the reason for that is the combination of the severity of the plaintiff's disability or the uniqueness of the plaintiff's disability and the unique demanding requirements of the job. So it's one of the rare cases, and we'll talk about another one right after this, where the employee is deemed truly unqualified for protection of the ADA. Similarly, in O'Donnell versus University Hospitals, the plaintiff suffered from severe anxiety, and she was unable to present live case discussions and file discussions to the other physicians in her medical fellowship program. The court here goes to great lengths to stress that the medical fellowship at issue in this case was not a traditional or typical job, and the requirement that the physician be able to present live, real-time case discussions with her fellow doctors and with the other members of the program was so essential that she couldn't in any way be excused from it, either partially or completely. Red flag for plaintiffs here is, whenever the plaintiff asks to be fully excused from participating in, part of the job or some aspect of the position, they're not going to fare particularly well in ADA cases. And I would note a line of cases where, the plaintiffs are medical residents and fellows in particular, bringing ADA cases. They keep going up before the Sixth Circuit, and they don't fare very well in those fact patterns because the requirements of the job in those professions, medical professions, are very, very demanding. In Kirilenko-Eisen versus Board of Education of Danville Independent Schools, the Sixth Circuit ruled in favor of two school nurses who disagreed with the manner in which the school dealt with students that had diabetes. And so it stands for the proposition that the plaintiffs can engage in protected activity under the ADA where they advocate on behalf of others who have disabilities, not just their own disabilities. It's also notable for its analysis of causation, where there was a significant length of time between when the plaintiff engaged in protected activity and when the school district decided not to renew her contract. And the court indicates that the non-renewal period was the school district's first meaningful opportunity to retaliate against the plaintiff, so that causation was established. Thanks to Patty Sandler for letting me know that the slide wasn't caught up. I appreciate that. In the next Sixth Circuit case that I would flag, and I think it's the last Sixth Circuit case we're going to discuss today, which is Fisher versus Nissan North America, Inc. It starts on page 17 of the materials. I would say that this case is another must-read case to understand the current state of the law in the Sixth Circuit on ADA reasonable accommodation claims. One reason is that the Sixth Circuit currently says that failure to accommodate claims are by definition direct evidence claims, because if the fact finder believes that an employer failed to accommodate, then and failure to accommodate is a form of disability discrimination, then discrimination is established without the need for any further inferences by the fact finder. This case is also the factual opposite of the Chancellor case and the McDonald versus UAW center case that we discussed earlier, because the record shows that Fisher was diligent in asking his supervisors and human resources representatives for accommodations, and that he proposed several different accommodations, including a transfer, extra break time, schedule modification, and that Nissan refused to consider them, and was even hostile to the idea that he would ever get an accommodation. It's also the opposite of those cases, because the court found Fisher was reasonable for leaving the job and not returning, where the employer refused to discuss possible accommodations with him and even kind of gave him a warning that, expressing doubt that if he was asking for these accommodations, he wouldn't be able to keep his job. Another important aspect of this case, and what really differentiates the ADA case law from the state cases under the Michigan Persons with Disabilities Civil Rights Act, is that the Sixth Circuit rejected Nissan's argument that because Fisher's absences were caused by disability, that rendered him unqualified for the job. Under federal law, if the employee's attendance or performance issue is related to disability, then the question is whether a reasonable accommodation is feasible. And if a reasonable accommodation is feasible but not provided, or if the employer doesn't engage in the interactive process, then the plaintiff can win and the employer will be liable. Under state law, it's 180 degrees the opposite. If the performance or attendance issue is related to disability, then the employer is not disabled within the meaning of the state statute. So in Michigan state law cases, the plaintiff has a burden to prove as an element of their case that the medical condition is unrelated to doing the job. Whereas in federal cases, if the performance of the job or the problem on the job is related to disability, it triggers obligations to accommodate, and the plaintiff can actually prove their case. Again, one last reason why this case is sort of the opposite of the Chenka and McDonald cases is that in this case, the court found Nissan responsible for the breakdown in the interactive process in determining reasonable accommodations. And that's what caused, in part, the Sixth Circuit to reverse the grant of summary judgment for Nissan. So it's always important to develop a good record as to what each side did or did not do in the reasonable accommodation and interactive process. That's going to be outcome determinative in a lot of these ADA cases. I've put a lot of several U.S. District Court cases in the material starting on page 20. And I'll only discuss a few of them here today. The first one is Brody versus Culture Source, which is, it's an ADA case in name, but I would flag this case for a recent analysis of when an arbitration agreement is enforceable. Judge Stee wrote a pretty good opinion, analyzing the arbitration agreement in this case and whether it's enforceable. And the key fact is that the plaintiff was presented with a arbitration agreement in her original application on a computer screen, and the court found that in that context, it wouldn't have alerted her that she should take time to consider the arbitration agreement before agreeing to it, and whether she had the right to consult with an attorney before signing on to it. So the court on that basis found it to be unenforceable. So again, not really an ADA issue so much as sort of a issue on the enforceability of arbitration agreements in all cases. The next case I would flag from the district courts is Vaughn versus Dawn Food Products, Inc., which is on page 23. And this is a part of that series of cases where the employer's delay in processing or responding to an employee's accommodation request does not in and of itself establish a failure to accommodate. A good reminder to the plaintiff's side lawyers that employees should always identify positions that they allege should be available or that they should be transferred to as part of the reasonable accommodation request. Again, that's, transfer to a different position is something that can be reasonable under federal law, is not going to be reasonable under state law. And another reminder that employers are always in a better position in defending these cases if they follow best practices and document making sincere efforts to find a position or to provide an accommodation to the employee. In Freeman versus Learning Care Center, the plaintiff had a severe allergic and asthmatic reactions to dust and chemicals, and other things caused environmental contaminants in her workplace due to construction at the office. And she asked for a work from home accommodation. And this case demonstrates a stronger fact pattern for when work from home accommodations are going to be found reasonable, which is when there's an extensive record of the employee successfully working from home and performing her job well when working from home, combined with evidence that other non-disabled employees are able to work remotely, which defeated the employer's position, which is that in-person attendance was an essential part of the job. employee in this case provided, repeated doctor's notes asking for work from home accommodations, and contrary to what we usually advise plaintiffs, which is if you're asking for a work from home accommodation or medical leave as an accommodation, you always want to put, if possible, an end date to when the accommodation or when the work from home period or medical leave would be expected to end. In this case, the employee did not have an end date in her accommodation requests, but the court found it reasonable because the medical providers also said that the environmental factors triggering her asthma could settle with time and no longer cause a problem once they were cleared out of the workplace. So again, kind of indefinite and dependent on the employer's ability to clean up the air, but still found to be reasonable by the court. In Sedaris versus Henry Ford Health System, which is on page 24 and 25, the lesson here is to always pay attention to whether there's more than one major life activity affected by the employee's medical condition. The court found that driving, for purposes of driving to and from work, was not a major life activity under the ADA, but that the plaintiff's wrist injury disabled him in other major life activities, such as performing manual tasks. In Meggert versus Decorative Panels, which is on page 25 and 26, this is a case about what happens in terms of the ADA when an employee returns from an extended medical leave that exceeds the 12 weeks of FMLA leave. It's a decision on the pleadings, and so it stands for the proposition that reinstatement to the plaintiff's former position is not necessarily unreasonable as a form of reasonable accommodations. The employer here was probably asking for a little too much in terms of asking the court to find that reinstatement to the prior position is never a reasonable accommodation as a matter of law. I'm getting a note to wrap up, so I will leave with two state court cases. The first is Terrell versus University of Michigan, which says that state claims under the PWDCRA against state agencies, in this case, the University of Michigan, in those cases, the employee is not required to satisfy the prerequisites of the Court of Claims Act when they bring their claims in the circuit court. I'd say that's a must read for anyone that's going to be bringing claims against any state agency. The next case to note would be Nave versus McLaren Bay Region on page 30, where the plaintiff lost at the pretext stage, but still established a fact question on the issue of disability through her own testimony regarding her hearing impairment. Oh, to answer the question, under Tyrell, the period of limitations, the court didn't address that, but I'd be happy to take a look and respond to what the statute of limitations would be in a circuit court case brought under the state statute against a state agency. My gut tells me I'm not 100% certain that it would be the 3-year statute. The last case is McKenzie versus Department of Corrections, where the court clearly held that the state court and the federal court had concurrent jurisdiction over ADA and Rehabilitation Act claims, so that employment discrimination plaintiffs who have exhausted their EEOC administrative remedies can go to state court or federal court with their ADA claims. So thank you for the chance to present today. I'm available by email. I should have put my email address. I'll type it into the chat. If anyone has any questions about any of these cases, please let me know, and I'd be happy to talk about them. So thanks, everyone.
Thanks, Kevin, for your time and your information today. Sorry we had to ask you to wrap up, but of course our little delay at the beginning wasn't helpful. But I see you put your email, so if anybody needs to reach out to you with some of those questions, there's a lot of cases in there. Some I'd read, and some I'm sure lots of people want to read. So I appreciate that. I'm excited to introduce our next speaker. Erin Donahue is with White Schneider in Lansing, Michigan. She is a shareholder with White Schneider. If you're here with us, Erin, feel free to say hi. We do have a video for Erin today because she has been joined in the last year when I've seen her. Oh, she is there. Yay. I was going to say she's mostly been joined by her new assistant who has been very helpful during our council meetings. And this is helpful. Yep, I know this is often wake time. So Erin went ahead and helped us out a lot by taping her presentation in advance. She mostly represents public sector members, nurses, police officers, and labor organizations. So she is the perfect person to do our MERC update. So we'll play her video now. And it's always good to see Madison. So I'm glad she joined us today too. Thanks, Erin.
Hi. Good afternoon. Welcome to the MERC update. Just like the rest of the planet, 2020 was an interesting year for MERC. As the Snyder Commission goes out and the Whitmer Commission comes in, there's been a lot of dissent among the commissioners, as well as a lot of disagreement over the scope of the decisions, whether they should be narrow or broad. So it'll be interesting to see how future commissions deal with the decisions from this past year. But let's dive right in. Instead of doing the comprehensive outline that I usually inundate you with, this year I've decided to do a much more in-depth look into the cases that I think are the most important from this past year, which I've included in this PowerPoint. So let's get started. Just a quick review, Michigan Employment Relations Commission, MERC, is the administrative body that resolves labor disputes for mostly public employees in the state of Michigan. PERA is the statute. PERA is modeled after the National Labor Relations Act, so the commission will often look to NLRB precedent for help with interpretation. The current commissioners, the chair is Sam Bagenstoss, although the Detroit News has recently reported that the Biden administration has tapped him for the position of general counsel of White House Office of Management and Budget. It's my understanding that he has already resigned from MERC. So we wish him well in that new position, and we'll have to wait and see who gets placed in his spot. The other two commissioners are LeBrandt and Pappas. Also this year, Administrative Law Judge Julia Stern retired and has not been replaced. So at this point, there are two ALJs hearing MERC cases. That's Judge Pelt and Judge Calderwood. This slide just has the provisions of PERA that we're going to be talking about today. I'm not going to go through this specifically. It's just here for your reference. So the first case we're going to talk about is the Renner case. This may sound familiar. It's been around for quite a while. This is a Court of Appeals decision where the employee, the charging party, had been disciplined by the employer, and he had filed a grievance with the employer. The employer said, you can't file the grievance, only the union has the right to go through the grievance process under the contract, and Renner, the charging party, was a non-member of the union, meaning he had opted out of paying dues. After Right to Work passed, this union had taken up a policy where non-members would be required to pay a fee upfront when they needed individual, what the union called direct representational services, such as grievance processing. The union differentiated this kind of service from what it called collective labor representation services, which would include collective bargaining and a ULP on behalf of the entire union. Those latter things were what the union considered to be required under the DFR standard for non-members, but the union did not believe the DFR standard extended to the individual representational services, which is why it believed it was okay to charge a fee for those services. Renner, the charging party, he filed a DFR charge against the union, asserting that this pay-for-service policy violated his right to be free from discrimination as a non-member. The administrative law judge, the commission, and the Court of Appeals all agreed with the charging party. The union here had made several arguments about why it should be able to have these pay-for-services policies. First, the union had said that the policy was legal because PERA allows union to make its own internal rules. The court disagreed with this and said the internal rules are limited to acquisition or retention of membership. This would not be one of those rules. The union also argued that PERA only bars charges required as a condition of obtaining or continuing employment, not for obtaining services. And the court again said, first of all, grievances, this kind of thing, this kind of service to non-members could very well be about obtaining or continuing employment, but even if it weren't, it still would violate their Section 9 rights. The union also argued that Janus referenced pay-for-service agreements with non-members. The court said Janus doesn't permit that kind of thing, it just references it, and as far as a state law may allow it, and of course PERA, the Michigan state statute, does not allow it. Finally, the union made the argument that it would violate their First Amendment right to freedom of association if they were forced to represent non-members. The court disagreed with that as well, saying, first of all, this is not a situation of forced inclusion. This is about a procedure. And second of all, the argument is undermined, according to the court, by the fact that the union would be willing to associate with the non-member as long as they paid the fee. So the lesson here is unions can't require pay for service at this point. The benefits of a contract have to be offered equally to members and non-members. You know, an interesting question might be, what if a grievance procedure in a collective bargaining agreement was open to the individual? What if you didn't need the union to take it through the grievance procedure? An individual could file a grievance, an individual could hire their own counsel to take it through the arbitration process, including hiring the union if they wanted to. Would they then be allowed to pay the union to represent them through the grievance procedure? You know, I don't know. It's a question I think that's still out there, and maybe we'll see it come up in the future and get a decision then. So the next case is City of Grayling and Hatfield. This is another DFR case, although there's also a ULP in this case. This is a very factually dense case. The charging party was a firefighter and a police officer. He was removed from his bargaining unit because his position was found to be supervisory. His position was later eliminated, and he was offered the position of patrol officer, which put him back in the bargaining unit. Once he was back in the bargaining unit, he learned that the employer's position was that he was moved to the bottom of the seniority list. He didn't think that was correct, so he contacted his union representative, and the union told him there was nothing they could do because they didn't have a contract in place at the time. They were between contracts. And so therefore they said they couldn't do anything about it. Now, obviously we all know that that's not accurate. The grievance procedure survives expiration of a contract. So they could have filed a grievance, but that's not what the union told him. Interestingly, testimony also showed that the union had said to the employer, if you place Hatfield anywhere other than the bottom of the seniority list, we'll file a grievance. So it certainly appeared that the union was aware that they could file grievances. But either way, no grievance was filed. Shortly thereafter, Hatfield was given a letter to sign for his new position that listed him as a probationary employee. He again contacted the union and said, I don't think this is right. The union said, again, we don't have a contract in place right now, so there's nothing we can do. During the same time period, Hatfield was having had a run-in with a DNR officer. And when his supervisor asked him about this later, he was less than honest. Based on this, Hatfield was terminated from employment for dishonesty and insubordination. And because he was considered a probationary employee, he didn't have just cause protection. So after this, Hatfield filed a ULP charge against the employer alleging discrimination based on his union activity, as well as a DFR charge against the union. And the ALJ dismissed all of the charges. Went up to the commission, and the commission unanimously agreed that the charge against the employer should be dismissed. Commission Chair Bagenstos wrote, he had a partial dissent, where he wrote that the timing of the transfer of Hatfield was suspicious, but it wasn't enough to rise to the level of a ULP, so he agreed that it should be dismissed. However, regarding the DFR charge, the commission unanimously reversed the ALJ, saying that they believe there was a DFR. The union's failure to take either the seniority list or his termination to file a grievance over either of those met the high burden of a DFR. Now, for a DFR, a charging party must establish both that there was a breach of the DFR standard, which requires the union to act without hostility or discrimination. They have to act in good faith and with honesty and avoid arbitrary conduct. So they have to show that, the charging party would have to show that, as well as a breach of the collective bargaining agreement. So in this case, the commission found that the union's clearly incorrect statement about not being able to file a grievance, not being able to do anything for this member in these multiple occasions, was a product of hostility and inept conduct, and it showed interest. It showed indifference to his interest. So the commission then moved on to look at whether or not there could have been a violation of the contract, and they found that, yeah, based on these facts, it's likely that there was a violation of the contract. Therefore, they found that there had been a DFR. Now, the remedy is where this case gets really interesting, because this is where there was a dissent. So the majority of the commission issued this remedy. They said it should be remanded back to the administrative law judge, who should issue an order recommending that the employer and the union arbitrate the discharge and set out the time frame when it should be arbitrated and when the decision should be made. That the ALJ should say the cost of the arbitration should be split between the union and the employer. The union should pay costs for representation for charging party, and that the employer should pay costs for any MCOLS recertification that was required. Now, the tough thing about this order is there's no finding against the employer of any kind of ULP, and so the employer has to voluntarily agree to this, which seems unlikely. So the majority said if the employer is unwilling to arbitrate, the union needs to pay all of charging party's damages, minus any back pay mitigation. So that's the remedy from the majority. This is a big and dramatic remedy, and Commission Chair Bagenstos dissented from this, saying MERC doesn't have the kind of jurisdiction to order that. First of all, he says they can't order a remedy of back pay unless there is a finding that he was fired with cause. And of course, there isn't going to be that if the employer doesn't agree to arbitrate, which frankly would be the logical thing to do, because why would they? The remedy also puts Hatfield in a better position than he otherwise would have been in, because under in the existing situation, there was no existing contract, which means there was no right to arbitrate. Arbitration does not survive the expiration of a contract. So although he couldn't have arbitrated the original grievances that should have been filed, the majority would have him arbitrate now. Bagenstos explained this remedy as more about imposing a punishment on the union than it was about making Hatfield whole. So the lesson here, does the commission now have broader remedial jurisdiction than we've seen before? It's hard to tell. We don't have anything on remand yet from the ALJ. There's nothing from the Court of Appeals on this, so we don't really know where this is going to go from here, but stay tuned on this one. Okay, the next case is Hurley Medical Center. I realize part of the title is covered with the video. Sorry about that. This is a case where the employer had for over 30 years provided office space and equipment to the union at no charge. There had been small changes. They had moved it periodically, but they had never demanded payment for any of it. Both parties benefited from this situation with the union office, usually right across the street. And it was made it obviously easier for both parties to meet with the union and work things out. Then one day, the employer sent an eviction notice to the union saying they needed the space for something else. The union filed a ULP saying either this was an unlawful midterm modification of a contract term without bargaining, or this was a unilateral change of a mandatory subject without bargaining. And either way, you can't do it. The employer agreed that it was a mandatory subject of bargaining, but asserted that the fact that they had been providing office space for free was an unlawful contribution under Section 10(1)(b) of PERA. So the administrative law judge determined here that there was a ULP and no exceptions were filed. So the ALJ decision stands on this one. The ALJ disagreed with the union that this was covered by the contract, but instead found that there was a past practice that had been established by the parties such that it created a term or condition of employment. Just as a quick review, the elements for past practice, a practice has to be mutually accepted by both parties, and either the contract is silent on the subject and there's a tacit agreement that the practice will continue, or the contract is not silent on the subject, but the parties are acting contrary to the contract language, in which case the practice has to be so widely accepted as to create an amendment to the contract. In this case, the ALJ found that the lesser standard applied, the contract was silent, but he stated that he would have, it would have met the higher standard as well if the contract had discussed it. Regarding whether it was an unlawful contribution as alleged by the employer, the ALJ said that didn't apply. The mere fact that the employer is providing a benefit to a union doesn't violate PERA. That could be read as hugely broad. Anytime an employee is given 15 minutes to talk about a grievance, that could be a contribution. That doesn't necessarily mean that it's unlawful. The purpose of the provision was to prevent subversion of the union's independence. So the lesson here, a couple lessons here. First of all, watch out for past practices. They can create terms and conditions of employment that are not in the contract, but keep an eye on which standard is going to apply. And regarding benefits to the union, you know, it doesn't necessarily, just because there's a benefit, it's not necessarily unlawful. So to employers, if you're going to argue that something is an unlawful contribution, if you've been doing something, giving some benefit to the union that you no longer want to give and want to argue that it's an unlawful contribution, you're going to need to show that it's a detriment to the union's independence, not just that it's helpful to the union. Okay, this next case is the first Bay City case. These next two cases will have the same parties in them, different ULPs. So this first one, the employer decided to unilaterally stop issuing paper pay stubs. The employer had previously required all employees to get direct deposit on their pay, but they still printed paper pay stubs. They decided to stop doing that and instead created an electronic portal that the employees could use to print out their own pay stubs. The union filed a ULP over this, saying that this is regarding pay and therefore it's a mandatory subject to bargaining. Judge Stern agreed and found that the employer had committed a ULP by not bargaining over this. The employer filed exceptions, and importantly, after the ALJ decision, but before the commission decision, the parties agreed on a successor collective bargaining agreement that included a waiver clause. So on this ULP, it was a split decision. The majority found that because the contract covered the issue, the employer did not fail to bargain. Commission Chair Bagenstos dissented and said that the contract did not cover this, didn't talk about paper pay stubs at all, and therefore the employer should have bargained this issue. This is a pretty narrow finding. Obviously, it's these specific facts with this specific contract, but the bigger issue here is that the majority included a significant amount of dicta regarding technology and talked about how in this computer age that we live in, it should be expected that employers are going to want to implement new technology and employees should be willing and able to do that, that it's the employer's prerogative to do that. The decision doesn't explicitly say it, but it could certainly be read to assert that the unilateral implementation of technology should be found to be a permissive subject. Now, the Commission Chair Bagenstoff strongly disagrees with this. In his dissent, he said this is contrary to the case law that the majority is relying on, it's contrary to the statute, and several times he said that he doesn't think that future commissions will or should rely on this dicta. So this is the latest commission statement on technology. It's extremely broad, or at least it could be read to be that way. But keep in mind that there have been significant changes to the commission since this decision was issued. 2 of the 3 commissioners are gone, and the only remaining commissioner, Commissioner LeBrand, his term is up at the end of June. So stay tuned to see what happens in the future with technology. The next case, the other Bay City case, is regarding cameras that were installed in sanitation trucks. These cameras were pointed at the drivers, and the union filed a ULP charge asserting that the cameras were a mandatory subject of bargaining. The employer disagreed and said the cameras are for safety reasons, and therefore it's a management right and not required to be bargained over. ALJ Stern found that the cameras were a mandatory subject of bargaining, and therefore the employer had violated PERA by failing to bargain over them. The employer filed exceptions to this decision. In the meantime, as I mentioned in the last case, the parties were bargaining, and they finalized a new CBA before the commission issued its decision. This new CBA contained provisions regarding safe working conditions, as well as the express waiver of anything that is contained, any issues that are contained in the contract. So in this case, the commission unanimously determined that the cameras were covered by the contract and that the pending ULP was expressly waived. So the commission found that they didn't need to determine whether it was a mandatory or permissive subject of bargaining because the charge was going to be dismissed as waived by the union. All 3 commissioners wrote concurring opinions in this case, mainly, frankly, to continue their disagreement about the prior Bay City case. But Chair Bagenstoff also used this opportunity to explain why he had found differently than he had in the prior case. And he pointed out that the employer had always taken the position that the cameras were a safety issue, and therefore the union was aware of that while they were bargaining. And since that was included in the new contract, the right to bargain it had been waived after the new contract. So the lesson here is, if you have a pending ULP and you're engaged in collective bargaining, be very, very careful if you don't intend to settle the ULP or waive it through settling the contract. It needs to be explicitly stated if you want the ULP to be able to survive, because if the issue of the ULP is covered in the new contract, you may very well find that the ULP will be dismissed based on the new contract, even if that's not what you intended with bargaining. So make sure that's at the front of your mind when you're engaging in bargaining. So the next 2 cases are also the same parties. This is the Detroit Firefighters Association. This is a case where the charging party objected to a policy that the employer had put in place saying that firefighters had to clean up blood and other biohazard from crime scenes. They said that this was a mandatory subject and they should have had to bargain over it. The ALJ disagreed and dismissed the charge, and there were no exceptions filed, so in this case, the ALJ decision stands. This new policy brought in by the employer came up after an incident at a murder scene where the firefighters were called out and nobody knew who should clean up the mess and frankly, how to clean up the mess. And so they created a policy called the Bodily Fluid Aftermath Cleanup Policy, which required firefighters to clean up blood and other hazmat from crime scenes, even if the firefighters weren't called to the crime scene while it was going on, even if they were called in just after the fact. The respondent employer said that they didn't need to bargain over this new policy because this was just a clarification of existing job duties. This wasn't something new. They pointed to a past practice that the firefighters had where they would do what were called wash downs, which usually involved a car accident where there could be glass or other debris that needed to be washed away. And there could be blood involved as well, and they would wash that away. They also, the employer also said that the safety concerns with this new policy weren't really greater than the safety concerns with the firefighters' original job duties. So the ALJ disagreed with these arguments from the employer, saying that car accident washdowns are vastly different than cleaning up from crime scenes. And the safety concerns here are outside the scope of the normal safety concerns that the firefighters had to face. Now, the ALJ, though, still found that they didn't need to bargain it, even though it was a mandatory subject of bargaining. None of the employer's arguments took it out of the realm of mandatory subject of bargaining, but the CBA had a very, very specific management rights clause that the ALJ found covered this issue. And therefore, the management was not required to bargain this. They could just implement this. Now, compare this to cases where you have a broad management rights clause, which is frankly a lot more common. And generally, those are found not to constitute a waiver of bargaining rights. So the lesson here is be careful about management rights clauses. From an employer perspective, the more specific you can be, the better. The better it's going to actually constitute a waiver. From the union's perspective, be skeptical when management is telling you, I don't have to bargain this, it falls under management rights. If it's broad, it may not apply. If it's specific, it probably will apply, but watch the language carefully. So our last case today is, again, the Detroit Firefighters Association, but this has to do with EMTs and paramedics. In this case, the employer had installed a new CPR monitor system in the ambulances for the EMTs and paramedics to use on patients. It was called ZOL-X, and basically it was a heart monitor and defibrillator system that would give real-time feedback to the person doing CPR to tell them how they're doing and what they should be doing to help the patient. The union did not object when the employer got this new system, did not demand a bargain over it when it was installed in the ambulances. However, during the training to use this, some of the union members asked whether this data could be used for disciplinary purposes, and the employer's training official assured the union this is not going to be used for disciplinary purposes. This is just for quality assurance and improvement. So, not surprisingly, the very next month, the data was indeed used for disciplinary purposes. The two EMTs had performed CPR on a patient. The patient's family members had filed a complaint, and so the employer wanted to look in to see what the EMTs had actually done. So they looked at this ZOL-X data and determined that they had not done what they should have been doing, and the two employees were discharged. The union, then filed a ULP charge against the employer, saying they were required to bargain over the use of the ZOL-X data for disciplinary purposes. Judge Stern found that although the installation and use of the equipment is not itself a mandatory subject of bargaining, the use of the data for disciplinary purposes is a mandatory subject of bargaining, and therefore the employer should have bargained with the union over it. The employer filed exceptions to this, asserting that because the CBA covers the installation of the equipment and the CBA covers discipline in the just cause provision, that they shouldn't have to bargain over any of these issues. The commission issued another split decision on this finding. They determined that there was nothing in the contract, the majority determined that there was nothing in the contract that covered the use of the data for disciplinary purposes. The fact that the employer was allowed to install and use the equipment without bargaining didn't mean that they're excused from bargaining over the effect of the use of the data. So they were required to bargain over the use of it for disciplinary purposes. The employer had also argued that the union waived the right to bargain because they had never demanded to bargain. The majority of the commission didn't agree with this either, pointing out that the union had actually asked whether it was going to be used for disciplinary purposes and had been told that it would not. And the first time they got notice that it would be was after the employer had already used it to investigate these two EMTs. So by the time it was presented to them, it was a fait accompli, the commission said, and therefore they had no duty to demand to bargain over it. Commissioner LeBrandt dissented in this one. He said that the use of the data is covered by the contract because the installation of the equipment is covered by the contract. He cited to a lot of case law with very specific facts regarding unilateral installation of equipment. And he also argued that the union had waived its right to negotiate by failing to demand because he said they should have demanded after they learned that the employer was already doing it. So he obviously disagreed on the outcome of this one. The lessons to take away from this one is effects bargaining is important. Unions, remember that even if you can't demand to bargain over the installation or implementation of something by the employer, it doesn't necessarily mean you can't bargain over the effect of it, especially if that effect is going to involve discipline or discharge. So you're going to see that a lot when it's something that could be used to surveil employees, which could obviously easily lead to discipline or discharge depending on how it's used. So keep in mind effects bargaining and make the demand as soon as you know about the issue. That's all I have for you today. Thank you for your time and enjoy the rest of the seminar.
Hello again. We'll be bringing on our next presenter, Jennifer McManus. She is a excellent plaintiff's employment attorney who represents persons from beginning to end, from the severance, from the termination while they're still employed, and right through to their jury trials. She has a lot of information today on what we call alphabet soup, often the WPA, FLSA, FMLA, and the like. And so I'll let her, as soon as we see Jennifer pop up here, we'll get started with her presentation.
Thanks, Heidi.
Here we go. No problem. Hey.
All right, so I promised Heidi I would talk quickly and try to keep our schedule on track. So I will do my best for everyone to keep us on track. So to get started, first of all, I do have to thank a new attorney with our office, Ryan Rosenberg. She really did the heavy lifting with compiling our cases and helping to gather all this information. And I want to note that I submitted my materials to the State Bar, but since then, as is often the case when we all start rereading what we do, I've since made a lot of edits. So, and changed things and added things and so forth. So I apologize for that if it causes anyone any inconvenience. I'm happy to send over new materials that anyone that sends an email to me would like to have. I'm going to be sharing them on the screen as well. They're pretty much the same cases, just some edits to some of the summaries, things that I picked up on as I was rereading the cases that I thought might be useful. And then, as always, when I do this, I like to tell the audience that these cases are your cases. You're the ones that argued them at the motion hearings. You took the depositions, you engaged in the discovery. With some of these cases, you were involved for years. So it's really hard for me to give appropriate credit to the work he did when I'm talking about each case, probably for less than a minute. But so anything that I forgot to add or maybe mischaracterized, my apologies in advance, because I know that these cases meant a lot to all of you while you were working on them and representing your clients. So with that, I'm going to share my screen. Let's see. And we'll get started. Okay. Is my shared screen up? I believe it is. Okay. So the first case that we have here is Heidi, can you let me know? I should be better at this by now. Can you let me know, is the title page up here? I'm working on a dual.
No, you got your wrong screen up. You've got like your secondary screen, it looks like, with the Windows logo.
Yeah, sorry. I'm working on 2 computer screens right now, and I do this sometimes. This is why I need to get back into my office. Okay, there we go. All right, so the first case that I have here is called Viet v. Lee, and it's a Sixth Circuit case. I'm going to start with the Fair Labor Standards Act cases. So this is a Sixth Circuit case, and it's an FLSA case where the plaintiff sold copiers in Vietnam, and he claimed he was working 60 hours a week, but he lacked any records to support his estimate, and he did not provide specific facts about his daily schedule either. So the district court found that the plaintiff's testimony was too vague and conclusory to withstand summary judgment, and the Sixth Circuit confirmed that affirmed that finding, explaining that while there is a relaxed burden on a plaintiff to establish damages where the employer failed to maintain work records, the plaintiff still must meet at least their initial burden of establishing liability by showing the performance of uncompensated overtime work, and that the burden of proof governs the threshold question of whether the plaintiff worked overtime at all. The court said that even with the relaxed burden that the plaintiff had to establish working overtime hours, the plaintiff's testimony was still too vague to establish having worked overtime hours. Next case is Etherton versus Service First Logistics Incorporated. That's another Sixth Circuit case in which Judge Borman's lower court ruling was affirmed. In that case, Service First Logistics, Service First Logistics sued 2 former employees in state court for violation of their non-competes and misappropriation of trade secrets. The case settled and the claims were dismissed with prejudice. But then about a month and a half later, the employees filed suit in federal court for unpaid overtime wages under the Fair Labor Standards Act. Because the 2 employees could have raised the overtime claims in the exercise of, quote, reasonable diligence as counterclaims in the first action, Judge Borman and then later the Sixth Circuit ruled that the FLSA claim in the second action was barred by res judicata. The Sixth Circuit ruled that, or reasoned that the 2 claims stemmed from the same transaction, since both claims stemmed from the employment relationship and would likely have focused on the employee's duties at work. The court further explained, and this is a little bit of a distinction from how other circuits have ruled, that the fact that the parties had split sides did not impact the ruling. So being a plaintiff in one action and then defendant in the other did not matter in that ruling. In Torres versus Vitale and then Torres versus Vitale again, we have a situation where in the first case, the plaintiff, who was a former restaurant employee in Grand Rapids, brought suit against the restaurant, the owner, and its manager, seeking overtime compensation for his work as a general laborer. The manager's practice was to pay employees 40 hours a week on payroll and then pay all the overtime hours on a separate time card. The overtime hours are paid by straight time versus double time, and so then the plaintiff was able to certify a class and pursue his collective action under the Fair Labor Standards Act. In the meantime, in a later suit, the same employees brought a RICO claim against the restaurant manager and the restaurant. And the restaurant manager and the restaurant attempted to have that claim dismissed, saying that the RICO claim was precluded by the Fair Labor Standards Act. The Sixth Circuit ruled that while their claims of wage theft may be precluded by the Fair Labor Standards Act, where the RICO claim sought damages that were distinct from unpaid wages, and in this case, the RICO claim brought claims of mail fraud, tax fraud, and wire fraud, then it was not precluded by the Fair Labor Standards Act because the Fair Labor Standards Act was not the sole remedy for their claims there. While the Fair Labor Standards Act is a remedial scheme that precludes suit brought under more general statutory schemes, the Sixth Circuit found that that was not the case for the RICO claim. In Taylor versus Pilot Corp., another Sixth Circuit case, a former employee of a nationwide chain of travel centers brought an FLSA collective action alleging that the manager routinely altered their timesheets to avoid paying overtime. And the employee said that this happened across all locations as a matter of policy. The plaintiff managed to get collective conditional certification, and ultimately there were over 5,000 opt-ins. The company later asserted that all the claims were covered by an arbitration agreement, but in doing so, the company said that the arbitration agreement had been signed at a particular date. The plaintiff responded by saying, well, many of our opt-ins actually started working for the company after that date, so they may not have signed the arbitration agreement. And so the plaintiff wanted discovery on all 5,000 opt-ins as far as their employment dates, not full discovery, but just the employment dates. Obviously, the defendant did not want to agree to that. They wanted all the claims sent to arbitration. The lower court did compel discovery of the employment dates and denied the employer's motion to compel arbitration without prejudice, though. And so the Sixth Circuit then held that it did not have jurisdiction to affirm or deny a lower court's, affirm or reverse a lower court's decision to deny arbitration because the delay of a decision on a motion to compel arbitration did not constitute a denial of the petition to arbitrate. The Sixth Circuit later further explained that the employer's, quote, mild inconvenience of having to produce employment dates and the, quote, frustration of its preference to have a case submitted to arbitration as quickly as possible did not constitute irreparable harm, preventing Sixth Circuit jurisdiction over the matter. So the company did have to provide employment dates for all 5,000 opt-ins. In Perez versus Timberline, Eastern District of Michigan case, the U.S. Department of Labor brought an FLSA action against a timber harvesting company and its owner, alleging violations of the FLSA's overtime and record-keeping provisions. At issue was the timber company's payment of commuting and mealtime wages and the Department of Labor's inclusion of those wages in the overtime calculations. In this case, the defendant did not maintain records showing how much time the employee spent commuting or eating meals. So the Secretary of Labor's damage computations that included meal and commute time were adequate to determine unpaid overtime. The case also addressed an exception to the Portal to Portal Act, where, as in this case, the employer did have a customer practice of compensating an employee for commute time. Here, the defendant did not dispute that it has such a custom, so the exception to the Portal to Portal Act applied. In Oliver versus Corrigan Moving Systems, Grand Rapids, Judge Neff granted a motion for summary judgment based on the interstate commerce exemption to the FLSA, and I can tell you I've been burned by that. It's a tough one. So in that case, the moving company did not pay its employees for overtime hours for hours worked over 40 per week. Instead, it paid them it paid them overtime when their hours exceeded 50 per week. The court found that the employees fell under the purview of the DOT regulations as helpers and loaders, and also that the employees had a reasonable expectation that they could be called upon to cross state lines as part of their regular job duties. And so the court held that the FLSA motor carrier exemption did apply, and it granted the defendant's motion for summary judgment. In McKinnon versus L3 Communications Corp., the Sixth Circuit explained, dug into when an FLSA retaliation claim may proceed. In this case, the plaintiff was a senior director of human resources at the defendant's company, and she was engaged in an internal project where she was re-examining the classifications of some of the employees and also the pay practices for some of the employees. And in the course of her project that she was performing as part of her job, she advocated for some of the employees to be classified as non-exempt under the FLSA, and also asserted that many of them should be paid overtime compensation. She was ultimately terminated, and she brought a retaliation claim against L3, claiming that her push to have certain employees reclassified and paid overtime was retaliated against, and that her termination constituted retaliation. The Sixth Circuit, the district court granted summary judgment on her retaliation claim, and the Sixth Circuit affirmed, holding that the plaintiff's efforts to advocate for her co-workers' reclassification as eligible for overtime pay was not a, quote, protected activity under the FLSA because the complaints to the employer were made in the course of the performance of her official job duties. And so that portion of her complaint was dismissed, that claim of her complaint was dismissed. In Gallagher versus General Motors, Judge Cleland also granted a motion for summary judgment on an FLSA claim. Some employees of a General Motors plant brought an action under the Fair Labor Standards Act, claiming that GM failed to pay its non-union contract employees overtime wages, and also that GM failed to preserve required records. The district court denied the plaintiff's motion for conditional certification of the collective action because the plaintiffs failed to provide more specific information about who it was that they thought could be potential opt-in plaintiffs. They made only vague generalizations and failed to actually identify any potential additional claimants, while in contrast, the defendant presented evidence of varying work circumstances nationwide. So even with the lower standard for a conditional certification, the court found that the plaintiff still had to provide at least some evidence of other people that worked in similar circumstances as them. In DeLizo versus Ability Works Rehabilitation Services, 3 registered nurses that were formerly employed by the defendant brought suit alleging violations of the FLSA's overtime and training provisions. Now, the defendant paid the RNs flat fees for each patient visit that they conducted, no matter how long those visits took. And when the defendant filed this motion for summary judgment, it claimed that the plaintiffs, the RNs, were exempt from the FLSA's overtime provisions under Section 213A1, which exempts workers employed in a bona fide professional capacity so long as they meet the salary basis and primary duty requirements. In this situation, the defendants, there was no dispute about the primary duty requirements, but it really came down to the salary basis argument. Judge Goldsmith denied the defendant's motion for summary judgment, finding that the defendant failed to show that the nurses, the RNs, met the salary basis requirement, where it failed to keep track of how much time its nurses worked at each patient visit to determine whether their pay was averaged out, when averaged out over the number of hours worked, would have earned the plaintiffs the required threshold compensation each week. So even with the flat rate, it's still incumbent on the employer to keep track of how much time is spent at each job. In Parker v. Battle Creek Pizza, plaintiffs filed a motion for conditional certification on behalf of the employees at the pizza shop, and the defendant argued that the group of employees was not similarly situated because many of the plaintiffs were subject to arbitration agreements. In ruling in favor of the employees, the court, Judge Neff in the Western District, explained that the plaintiff's burden at the first stage is fairly lenient and only requires a modest factual showing that the plaintiff is similarly situated to other employees, even if ultimately the proofs may be inevitably individualized and distinct. In denying summary judgment and granting the motion for conditional certification, Judge Neff did acknowledge that this issue is in flux in the Sixth Circuit, but for the purpose of conditional certification, the plaintiffs were permitted to proceed. In Hurt v. Commerce Energy Incorporated, the Sixth Circuit addressed the outside salesman exemption to the Fair Labor Standards Act. In this case, the Ohio employees performed door-to-door solicitations for an energy company and were paid on a commission only. The employees brought a collective action against the energy company and its related entities. And after a jury trial, the energy company appealed the jury's decision that the employees were covered under the Fair Labor Standards Act, arguing that they were entitled to the outside salesperson exemption. The Sixth Circuit engaged in a de novo review of the responsibilities and job duties of the employees and found that the employees were not subject to the outside salesperson exemption. In doing so, the Sixth Circuit found that because the employees did not have authority to bind potential customers into electricity contracts, and that the energy company retained the power to actually finalize the sale, the employees were not, quote, making sales, and thus were not outside salespeople. Moving back to the Eastern District, in Morrissey versus CCS Services, the plaintiff was employed by a law firm working remotely. The law firm classified her as a non-exempt employee under the FLSA, but failed to pay her for hours she worked in excess of a 40-hour work week. She brought suit against the firm for FLSA violations, and when the law firm responded, they filed a counterclaim against her. The plaintiff then filed an amended complaint asserting that the counterclaim qualified as a, quote, adverse action for a retaliation claim under the Fair Labor Standards Act. Arguing that the law firm's filing of the counterclaim was motivated by her original filing of the underlying FLSA lawsuit. The court, Judge Borman, granted the law firm's motion to dismiss the amended retaliation count. The court explained that, quote, in order to sufficiently allege that a counterclaim is an adverse action in an FLSA retaliation claim, the plaintiff must put forth facts that the counterclaims were either baseless, frivolous, or in bad faith, with a retaliatory motivation. Judge Borman found that she had failed to demonstrate a bad faith motive and also noted that the counterclaim was compulsory pursuant to Federal Civil Procedure 13. In Osterman versus General RV, another Eastern District case, a former inspection technician of General RV alleged that the company failed to pay him for all hours worked and failed to pay him for his overtime wages. General RV compensated the plaintiff under a flat rate system, which is a system in which the repair facility estimates how many hours it should take to do a job and then pays their technicians their hourly rate for the number of hours estimated to do the job, regardless of how long it actually takes for the job to be done. General RV argued that based on that pay system, the plaintiff was exempt from overtime provisions under the Fair Labor Standards Act since the flat rate constituted a commission basis. The court, Judge Dawkins Davis, conducted an in-depth analysis of both Sixth Circuit and out-of-circuit case law on whether a flat rate system constitutes a commission. And after a careful review, she found that General RV had not put forth sufficient evidence to show that its particular flat rate system reflected the proportionality that was required to show a commission-based system. The court noted pretty pointedly that General RV declined to provide business records such as customer receipts that could readily indicate whether the price paid by the customer reflected, at least in part, plaintiff's labor. The court did find that while the violations were made in bad faith, because the defendant really failed to do anything to investigate whether its pay practices were legal, they were not willful because there were no prior violations or complaints on record. In Bruce v. Sana Health, the plaintiff filed lawsuit against Sana Health for FLSA overtime wages. Sana filed a counterclaim alleging that Bruce was liable for conversion of company property. He was allegedly selling company property on Facebook Marketplace. But the court dismissed the counterclaim, finding that it was not based on a common nucleus of operative facts through the plaintiff's FLSA claim. And the court declined to convert supplemental jurisdiction over it as well. In Eberline v. Douglas Holdings, former students of the Douglas J. Cosmetology School brought a class and collective actions against the school for failing to pay the students for cleaning, laundry, and restocking products during their clinical training. The Sixth Circuit ultimately held that the primary beneficiary test applied to determine whether the janitorial work was compensable under the Fair Labor Standards Act. The court examined who the beneficiary of the work relationship was, asking whether the employee had an expectation of compensation, derived educational value from the work, or displaced paid employees. It reasoned that the primary beneficiary test was appropriate because janitorial duties are not part of the cosmetology school's curriculum and were not required to receive a cosmetology education. The court did make clear, though, that this primary duties test was only to be applied during the time when the students were actually engaged in this type of labor, and if they were entitled to wages, it was only during that time. So, speaking as quickly as I can, and moving on to the Family Medical Leave Act. Our first case here is Anderson versus Detroit Transportation. This is an interesting case where a transit police officer brought suit against the defendant alleging both interference and retaliation under the Family Medical Leave Act. Anderson went off on FMLA, providing a doctor's note excusing him from work. And then when he returned to work, he was required to submit to a drug test. The drug test showed certain painkillers that were prescription related, but his employer sent him back home saying he couldn't work while he was still on those painkillers. In the meantime, the employer continued to charge against his FMLA leave time while he was back home, but did not tell the officer that it was doing so. So then when the officer returned to work, he was told he had exhausted all of his FMLA time, and they terminated him. Both parties filed motions for summary judgment, and Judge Cleland denied both motions for summary judgment, holding that there was a genuine issue of material fact as to whether the officer was fired because of FMLA exhaustion alone, and whether the employer proffered a legitimate non-retaliatory reason for terminating him. The court explained that the defendant was obligated to notify the plaintiff that the time that he was off of work at the defendant's direction was counted against his FMLA time, and because the defendant had failed to do so, the plaintiff's FMLA claims could proceed. In Hicks versus American Axle, the defendant worked on a cleaning crew for its the plaintiff worked on a cleaning crew for the defendant's manufacturing department. In the case, Judge Maloney of the Western District characterized the plaintiff's attendance record as, quote, dismal at best, noting that she could have been terminated multiple times due to attendance, but was always cut a break instead. In March of 2017, the plaintiff did require an FMLA leave, but she failed to notify the defendant's FMLA administrator. And when she finally submitted her request, it was denied because it was late, and she had not identified extraordinary circumstances to warrant the delay. And so she was terminated from her employment. She filed an FMLA claim against the defendant for an interference claim, and the district court found that she had failed to show a claim of FMLA interference because she had failed to give her employer proper notice of her FMLA leave. In addition, the court found that even assuming evidence of FMLA interference or retaliation, her prior attendance violations established a legitimate non-retaliatory reason or non-discriminatory reason for the termination. In Smith v. Town Properties Asset Management, Sixth Circuit granted a defendant's or affirmed the grant of a defendant's motion for summary judgment based on the honest belief rule. In doing so, the Sixth Circuit said mistakes happen, including in the context of employment decisions, but not every mistake amounts to actionable employment discrimination. That's the lesson of this case. The plaintiff had taken FMLA leaves multiple times throughout her employment with the defendant. She took them without incident. Later on, a coworker mistakenly accused her of misappropriating about $14,000 worth of utilities and not paying for her parking spot. The employer investigated these claims, wrongly concluded that they were true, and terminated the plaintiff. The Sixth Circuit held that the employer's belief was an honest belief and that it constituted a legitimate reason for termination. And even though it was mistaken, it was not pretext for discrimination against Smith for her FMLA leave. In Brown v. Kelsey, the Sixth Circuit affirmed Judge Tarnow's dismissal or granting of summary judgment of a claim brought by an employee against her employer for FMLA violations when it failed to transfer her to her company's new entity during a acquisition. The plaintiff had, over the years, taken FMLA leave and had various accommodations for some physical disabilities, including asthma and the usage of a wheelchair at work and her age. The defendant granted FMLA leaves multiple times throughout her employment, but then she was terminated shortly after another leave. While she was on leave, the defendant came to determine that from 2006 to 2014, she had been given frequent mixed performance reviews, and the Sixth Circuit found that the company's determination that her performance needed improvement and included some significant criticism throughout her reviews constituted a legitimate reason for termination that was not pretext. This case, though, I brought to our attention just because Judge Clay did write a dissent, finding that the plaintiff had demonstrated a genuine dispute of material fact at each stage of the McDonnell-Douglas burden shifting inquiry, and specifically pointed out that all the relevant decision makers had knowledge of plaintiff's FMLA leave and her disability, and that there was a significant question of fact about whether that weighed in their decision to let her go. In Sukari v. Akibono Brake Corporation, the former employee alleged that she was terminated from her position in the HR department due to a bone disorder. The disorder affected her movement and her ability to do daily activities, and so she requested and took intermittent FMLA leave. Throughout her time working with the company, her supervisors advised her multiple times that she had attendance issues, that she had to avoid taking unauthorized days off work, and repeatedly advised her that they were concerned about her attendance issues. When she returned from a vacation, she texted her supervisor that she was too, quote, exhausted and bloated to go to work, and so she was terminated. Sixth Circuit found that the defendant put forth a legitimate non-discriminatory reason for her termination, including her poor attendance record. In Horn v. Robert Bosch Auto Steering, former employee worked for 2 years as a commercial manager, and in 2018, he notified his employer of the need for time off for medical testing. During his deposition, though, he admitted that he never actually asked for any specific time off and never actually put in an official request for FMLA leave. He testified that all he said was that he would need to take some time off from work due to pressing medical issues, but he was unsure about what kind of time off he was going to need. He further testified that rather than make an actual request for leave, he just wanted to, quote, prep them to let them know that, quote, hey, listen, I could be requesting some additional time off. The court granted defendant's motion for summary judgment, explaining, quote, this dooms his claim because under both the FMLA interference and retaliation theories of recovery, the employee must request the time off or give the employer notice of the intention to take leave. In Berger v. Auto Media, the plaintiff, and just have a few more FMLA claims, and then we have the whistleblower claim, but I'm going to run through Berger, and then I'm going to put my email on the chat so that I can send the updated materials to anyone that's interested. In Berger v. Auto Media, the plaintiff filed a suit, FMLA claim against Automotive Media LLC. The plaintiff worked as a project manager for over a year. The job was stressful, so she requested an FMLA leave. When she returned, she was assigned to a new position and placed on a performance improvement plan because during her leave, the company learned about performance issues that had occurred before she took her leave. She was terminated prior to the conclusion of the PIP. She brought FMLA retaliation and interference claims based on her assertion that when she returned from leave, she did not have the same position, she no longer had responsibility for a certain client account, and she no longer had her direct reports. The company responded that she was given other accounts and thus the job was functionally equivalent. The court, Judge Borman, granted the defendant's motion for summary judgment on the interference claim, explaining that when she returned from FMLA leave with the same paid benefits and essentially equivalent activities, or responsibilities, she was returned to her prior position and so was not denied benefits to which she was entitled to under the FMLA. But as to the retaliation claim, Judge Borman found that while the defendant had proffered a legitimate non-discriminatory reason for her termination, which was poor performance, the plaintiff had presented sufficient evidence of pretext, including temporal proximity and questions of fact for the reasons behind her termination, and so denied the defendant's dispositive motion on the retaliation claim. And with that, I will have to leave it to the materials for the additional FMLA claims and the whistleblower claims. Thank you.
Okay, thanks, Jennifer. Sorry to cut you short there. Obviously, we're running over, but we're just doing the best we can to get everybody the information that I know you're looking for today. Here's Maria Dwyer from Clark Hill with the EEO update, which I know everybody's been waiting for. And take it away, Maria. Maria, you got to unmute, and then they'll hear the good information.
Well, that's a good one, right? Thanks, Heidi. All right, let's start again. Hi, everyone. Good afternoon. We'll get started with sex discrimination. If I can flip my slides, right? All right. First case is Bostock versus Clayton County, Georgia, out of the Supreme Court. Supreme Court started the case as follows. Few facts are needed to appreciate the legal question we face. Each of the three cases before us started the same way. An employer fired a longtime employee shortly after the employee revealed that he or she is homosexual or transgender, and allegedly for no reason other than the employee's homosexuality or transgender status. Pretty impactful words by the Supreme Court. Gerald Bostock worked for Clayton County as a child welfare advocate. Under his leadership, the county won national awards for its work. After a decade within the county, Mr. Bostock began participating in a gay recreational softball league. Not long after that, influential members of the community allegedly made disparaging comments about Mr. Bostock's sexual orientation and participation in the league. Soon after, he was fired for conduct unbecoming a county employee. Donald Zarda worked as a skydiving instructor at Attitude Express in New York. After several seasons with the company, Mr. Zarda mentioned that he was gay and days later was fired. And finally, Amy Stevens worked at R.G.&G.R. Harris Funeral Home in Garden City, Michigan. When she got the job, Ms. Stevens presented as a male, but 2 years into her service with the company, she began treatment for despair and loneliness. Ultimately, clinicians diagnosed her with gender dysphoria and recommended that she begin living as a woman. In her 6th year with the company, Ms. Stevens wrote a letter to her employer explaining that she planned to live and work full-time as a woman. After she returned from an upcoming vacation, the funeral home fired her before she left, telling her this is not going to work out. While these cases began the same way, they ended differently. Each employee brought suit under Title VII, alleging unlawful discrimination on the basis of sex. In Mr. Bostock's case, the 11th Circuit held that the law does not prohibit employers from firing employees for being gay, so his suit could be dismissed as a matter of law. Meanwhile, in Mr. Zarda's case, the 2nd Circuit conducted and concluded that sexual orientation discrimination does violate Title VII and allowed the case to proceed. Ms. Stevens' case has a more complex procedural history, but in the end, the 6th Circuit reached a decision along the same lines as the 2nd Circuit, holding the Title VII bars employers from firing employees because of their transgender status. During the course of the proceedings in these long running disputes. Both Mr. Zarda and Ms. Stevens passed away, but their estates continued to press their causes. The Supreme Court granted cert, and the court reasoned, granting that an employer who discriminates against homosexual or transgender employees necessarily and intentionally applies sex-based rules. The court indicated that discrimination on the basis of homosexuality or transgender status requires an employer to intentionally treat individual employees differently based on their sex, and accordingly, such actions fall within the scope of Title VII as already written. Next case under LGBTQIA harassment, Doe versus City of Detroit. This is on page 1 of the materials, which everyone should have received from the State Bar. Shortly after Jane Doe began working as the Assistant Director for Grants Management for the City of Detroit, she took some time off to undergo sex reassignment surgery to reflect her gender identity as a female. The mayor and Doe's immediate co-workers were supportive of Doe during her transition. However, when she returned to work as Jane Doe, someone left her a gift bag with a sex toy and a hate-filled note. She requested that locks be placed on her door and a hidden camera installed. This was not done. A few months later, she received another 2 notes containing threats of violence. She was temporarily relocated to another floor, and locks and cameras were later installed on the floor where her office was located. Doe was returned to her office after the locks and cameras were installed. Although the person was not concretely identified, other employees complained that one coworker had made the disparaging remarks and believed that it was a particular person. And Doe believed that that individual should have been disciplined and fired. However, the city could not find substantial evidence that it was that individual, and she filed suit claiming that the city did not take appropriate action in response to her claims of harassment. The court held that the city did take prompt and remedial action calculated to end the harassment, even though it ultimately did not find who the harasser was. Sex discrimination continued. Page 5 out of the Eastern District of Michigan. Mary Jane Dixon used to work as a general sales manager for Adams Outdoor Advertising. Dixon claimed that Adams Outdoor was a boys' club and that her gender played a role in her termination. She also says that when she complained of gender discrimination, Adams Outdoor retaliated. Dixon complained that the regional manager asked her to get him a coffee during a meeting, even though she was the most senior person in the room, would talk over her and cut her off, would leer at attractive women in her presence, and that plaintiff was told that she did not get the role as the manager because she was a single mom, and he had too many women in the office with too much drama. Adams Outdoor, by contrast, says that the office where Dixon worked had too many managers and that Dixon had performance-related problems, and so she was eliminated to address the surplus of the managers. The court held that plaintiff was entitled to a trial on her sex discrimination claim, but dismissed her retaliation claim. The next set of cases are fair pay claims, and there were a lot of new cases in this area. You'll find them on your outline starting on page 2, and we're going to cover a few of them here. The first case, Galligan versus Detroit Free Press, out of the Eastern District of Manager, is a case that I call make sure your manager buys into your defense. Pretty bad as a defense lawyer saying that, but in Galligan, female news agency employees who worked as photographers or reporters brought in action against the newspaper and its parent company, alleging that defendants discriminated against them by paying them less than their similarly situated male colleagues in violation of the Federal Equal Pay Act and the Michigan Elliott Larson Civil Rights Act. The photographers identified 3 male photographers who worked at the Free Press at the same time as them, and who were paid more than them. The reporters identified 3 male reporters who also worked at the Free Press at the same time and were paid more. The court held that the pay disparity was not based on the Free Press's purported merit-based system, where the manager could not explain what the alleged merit-based pay system was during her deposition, and the case could go to trial. The second case, plaintiff Susan Walsh, age 61, and this is Walsh versus Donor International Limited on page 2 as well, began working for defendant in 2010. Defendant is a large advertising agency with corporate clients across many industries nationwide. Plaintiff, who began her career in the advertising industry in 1984, was hired by defendant as a senior copywriter, was subsequently promoted several times, although she remained a creative director until her termination in 2018. Her salary as the creative director was $127,000 during her time at Donor. Plaintiff worked on a team reporting to an executive creative director, Randy Belcher, who was making $174,000. Plaintiff filed suit alleging claims under Title VII and the EPA, and the court held that she raised sufficient statistical data to create an issue of fact. There's a lot of statistical data language in these cases, so you might want to take a look. The next case, Morgan versus United States Soccer Federation, Inc., was brought by the women's national soccer team. In March of 2019, plaintiffs brought their claim, and the court did allow for a putative collective action and a class action against the United States Soccer Federation. Plaintiffs asserted 2 claims against the defendants, violation of the EPA and violation of Title VII. They claim that the men's team received higher salaries than the female national soccer team, even though the women's team, we know, unlike the men's team, achieved largely unrivaled success, winning 4 Women's World Cup titles and 4 Olympic gold medals. In 2016, the court noted that the women's team began negotiating their contract, and when they did that, they decided that they would not engage in the same pay structure as the men's team had done when they negotiated their contract, which was a pay-to-play structure. And because they negotiated their contract differently with different terms, the court held and reasoned that the EPA had not been violated in this case. Next case, also under the Fair Pay Claim Act, plaintiff was employed in the HR department for defendant and received several promotions in her 10 years with the company. I always cringe when I get a case from an HR person. We know that they have all the details of the company. Here in 2014, she was promoted to a Human Resources Capital Manager East Division. Around the same time, defendant hired a new male employee for a Human Capital Partner position, slightly different title. The male employee had 0 HR experience, but was hired because the hiring partner liked him because he was a former police officer, and defendant thought that he would be a good fit with the company to oversee the HR sales division. Plaintiff was not offered the position or offered the opportunity to apply. Later that year, she was promoted to HR operations manager, but she was not given a pay raise. She complained about the pay discrepancy and pointed out after seeing her comparator's offer letter that she was being paid significantly less than he had. She also checked out a couple other offer letters and was able to compile information and data that supported that others were being paid, male co-workers were being paid more than she was, and the federal court allowed her claim to proceed. Next set of cases are under age discrimination. Bob versus Wilkie out of the Supreme Court on page 6 of your outline. The U.S. Supreme Court granted cert to determine the standard of proof for federal government workers who bring claims under the ADEA. The federal government argued that the employee must show that the adverse employment action would not have been taken but for the employer's bias. The employee alternatively argued that a more lenient standard should apply, namely whether age bias was a motivating factor for the negative employment decision. The Supreme Court confirmed the applicable standard for imposing liability against federal sector employees under the ADEA, which is a more lenient standard than the but-for causation standard, is applicable to claims brought against private sector employers. The Supreme Court specifically noted that that under this standard for federal sector employers, if a federal employee establishes that age played any part in the decision at issue, age discrimination can be established. Next case was mentioned by Kevin earlier this afternoon, Our Lady of Guadalupe, age discrimination and the ministerial exception on page 6 of your outline. These are a series of cases. In one case, a teacher at a Catholic elementary school brought an action against her school employer under the ADEA, alleging she was demoted and her teaching contract was not renewed so the school could replace her with a younger teacher. The United States District Court for the Central District of California granted summary judgment to the school and the teacher appealed. The United States Court of Appeals for the Ninth Circuit reversed. In the second case, a teacher at a different Catholic elementary school brought an action against her school employer under the ADA, alleging that she was discharged because she had requested a leave of absence to obtain treatment for breast cancer. The United States District Court for the Central District of California granted summary judgment to the school, and the teacher appealed. The United States Court of Appeals for the Ninth Circuit reversed and remanded and denied rehearing en banc. Following her death, the teacher's husband litigated her suit as a representative of her estate. Cert was granted in both cases, and the cases were consolidated here. The court held that the teacher's claims were foreclosed due to the ministerial exemption under the religion clause of the First Amendment, which protects religious employers from anti-discrimination lawsuits. The court explained that judicial intervention into disputes between the Catholic school and teacher threaten the school's independence in a way the First Amendment does not allow. This case bolsters the rights of religious schools and institutions to select their employees. Next set of cases are harassment cases. The first case, sex-based harassment, is on page 8 of your outline. No strict liability for sales manager. This is one of my favorite cases that I've reviewed in preparation of today. Plaintiff alleges she visited a Sears outlet store and was sexually harassed by a sales manager who was not a party to the case. Specifically, on a singular occasion in April of 2018, plaintiff visited a Sears outlet store in New Jersey and spoke with the sales manager, who told her, "What a pretty girl you are." And she told him she was looking for a refrigerator, and she showed him a picture of her kitchen so that he could get a sense of what the dimensions were. And he said to her, "Are those photos on there that I'm not supposed to see?" She responded, "No," in a businesslike fashion. And he said to her, "I'm married and so are you. I'm just trying to have some fun." Plaintiff said she no longer was interested in the refrigerator and left the store. She tried to complain to the store thereafter, but they did not pick up on her reports and complaints. And she filed her lawsuit, alleging that in the context of a public accommodation, employers should be strictly liable for an employee's harassment of patrons. The court disagreed, finding it was not plausible that the manager was acting within the scope of his employment, in particular where he said, "I'm just trying to have some fun." Next case addresses qualified governmental immunity. Michigan Court of Appeals case, Stanton versus Anchor Bay School District. Stanton entered into an employment contract with Anchor Bay School District in 2014, serving as the principal for Anchor Bay. And he worked at Anchor Bay with Pat Mikulski, who was a female security guard. Mikulski was Stanton's subordinate. During the 2015 and 16 school year, there was an incident that occurred involving a student who brandished a wooden penis in the school parking lot, which Stanton and Mikulski confiscated. Stanton alleged that he and Mikulski joked about the item during their employment at Anchor Bay. Mikulski accepted a different job with another district and resigned from Anchor Bay. And during the farewell gathering, you know where we're going here, Stanton gave Mikulski the wooden penis as a farewell gift with a note attached that said, "To Pat, hope your job isn't too hard." Stanton claims that Mikulski laughed about the gift, showed the gift to her family and children, and did not file a complaint concerning Stanton's gift. On May 30th, 2017, Ken Ward, Director of Student Services for Anchor Bay, received an anonymous letter stating that Stanton's gift to Mikulski was offensive. Ken Ward called a meeting with Mikulski to discuss the gift that he had given to Mikulski and requested that Mikulski, scheduled a meeting with Mikulski to discuss Stanton's gift and requested that Mikulski bring in the gift. She went home, retrieved it, gave it to him, and several weeks later, Stanton was pressured to resign and did so. He applied for a different job at Churchill in Livonia, received the job, received a positive reference from Anchor Bay, and 4 months later, on her own accord, Ken Ward called Churchill to report that Mikulski was the subject of a sexual harassment investigation and shared the details of what had occurred. Stanton was then asked to resign from Churchill. He filed suit against Anchor Bay and Ken Ward individually. It's a great former employee, right? Former coworker, excuse me. Kenward sought governmental immunity, alleging that her conduct was undertaken in good faith. The trial court disagreed and said that they were not clear how Kenward's conduct satisfied good faith requirement when it was 4 months later and was unprompted by the school district. The next set of cases are race discrimination. 2 cases addressing disparate impact claims, both on page 10 of your outline. In the first case, Defendants Civil Service Commission used an entry-level law enforcement examination as a screening tool for certain classified law enforcement positions within the Michigan State Police and the Department of Natural Resources. 2 versions of the exam are at issue in this case. The former version was used from March 2002 through December 2014, and the other version replaced the first version, and they are both at issue. They allege in the case that the applicants had to pass each exam with a minimum score and achieve a total minimum score to pass the exam. The 2014 test also consists of 3 sections: human relations and judgment, report writing, and reading. The first and third sections are similar, respectively, to the human interaction and reading ability sections in the other test from 2002. The report writing section of the 2014 requires applicants to watch a video, handwrite a report about their observations, and then answer multiple choice questions about the report. The handwritten report is never scored, and all test questions are multiple choice, and scoring is fully automated. Plaintiff Bell, an African-American male, took and failed the test twice and failed the new test once. So he failed the first test twice and the newer test once. He filed the present class action complaint in 2017, alleging that both exams have a disparate adverse impact on African-American applicants on 2 theories: disparate impact and intentional discrimination arising from defendants' failure to monitor the adverse impact of the examinations on African-American applicants. Plaintiff moved for class certification on June 29, 2018. He asked for cert for 2 classes, separating those who took the earlier exam and the latter exam. The trial court granted certification of the 2 classes, and the commission appealed. The appellate court held that the trial court's findings as to the requirements for class certification were not clearly erroneous, and that the court did not abuse its discretion by certifying the 2 classes. The second case, Bunkhart, plaintiffs were employees of the school and alleged discrimination based on age, sex, and race in violation of the Elliott Larson Civil Rights Act. First, the plaintiffs alleged discrimination on a disparate impact theory because the plaintiffs were paid less than similarly situated employees. The second count was also based on a disparate impact theory and alleged discrimination because the MOU and the agreement on how to place those transitioning onto a new pay schedule had a disparate impact on the older white female teachers like plaintiffs. The court affirmed the summary dismissal of the plaintiff's claims because there was no issue of material fact. The court reasoned, even assuming that the decision about how to transition plaintiffs to the K-12 pay schedule was a policy of defendants, plaintiffs cannot establish that it disproportionately impacted or burdened them more harshly than others. In trying to establish their claim, plaintiffs assert that the policy had a disparate impact on them compared to teachers that were already on the K-12 pay schedule. The K-12 teachers who were never on the MOP pay schedule are not the proper comparator group. The next case deals with statistical evidence, holding that statistics were only circumstantial evidence and not sufficient to establish a discriminatory pattern in this case. This one is on page 11 of your outline. Next case, although not exactly EEO, I couldn't resist. It's a whistleblower and FFCRA case. Thornberry alleged COVID-related complaints at her workplace. This is out of Kentucky. It's found on page 12 of your outline. She complained through the month of March of last year, when all of us were just starting to get our arms wrapped around the COVID issues and how to address things in the workplace. She complained that certain safety measures were not taken in the workplace. She told her employer that she didn't want to quit, but if the employer did not make the changes that she was demanded, she would not return to work. As a result of her threat, on April 1st, 2020, the employer fired her for not returning to work during the month of March and refusing to return to work during the month of April. We all know what happened on April 2nd. The FFCRA went into play, and she files her lawsuit claiming that the employer violated the FMLA by firing her and not giving her time off due to her COVID-related complaints and safety-related concerns. The court held that the FFCRA did not extend to complaints regarding safety concerns, and her claim under FMLA failed as well because she was not an eligible employee or a qualified employee under the FMLA based on simply not wanting to come to work because of her complaints of safety concerns. We're almost there, guys. Next case is retaliation, Wells versus Department of Corrections. This case goes into great detail about documentation that the Department of Corrections maintained, documenting the poor performance issues regarding Wells. Plaintiff began working for defendant at the Lakeland Correctional Facility in the summer of 2015 as a correctional officer. She stated that in June of 2016, she filed a charge of discrimination based in part on allegations that she received inadequate training and was improperly disciplined because she was a female and an African American. She was subsequently terminated. She claimed that her termination was a result of her charge of discrimination, and also that she was discriminated against during her employment there. The defendant, Department of Corrections, submitted tons of information regarding her poor performance, including failure to follow proper policy and procedure with regard to her job duties, unprofessionalism in the workplace, using her radio at work, talking on the telephone, addressing staff and prisoners, and telling them her personal business, and just a general lack of professionalism while performing her job duties. This was documented in performance evaluations and also documented in disciplines, and the court held that she could not establish her claims of retaliation. We're going to talk about a few miscellaneous topics. I had this in a larger section, but moved this because I know we're running a little bit short on time. So take a look at the arbitration cases starting on page 16 of the outline materials. Again, while not technically EEO, my two wonderful associates who put all these materials together went overboard and did an excellent job and added some areas, a number of arbitration cases, a number of labor cases, and I kept them in there because it's great work and I thought you could all benefit from the review. In these arbitration cases, the first one, the Facebook case, I thought it was very interesting. Employer must show the existence as it relates to an arbitration program and a court's decision whether or not to grant class certification or order the parties into arbitration. The court here in the Seventh Circuit said the employer must show the existence and validity of arbitration agreements for each employee it seeks to exclude from receiving class notice. So that's quite a bit of a burden on the defendant to establish, unless the plaintiffs concede that there was an arbitration program with respect to those groups of workers. The next two cases I thought were timely in light of COVID, the Amazon case and the Grubhub case. Both of those companies brought many of us through COVID last year. In those cases, the court looked at drivers who transport goods that cross state lines and whether or not they are exempt. The issue here is really on the class of individuals and whether the individuals grouped together work to move goods across state lines, not that that particular individual moves the goods. So they're good cases on whether or not drivers are exempt under the FAA based on the particular circumstances for that class of workers. The last case is a USERRA case. And in this case, Plaintiff Hartwood, a service member for American Airlines, brought an action alleging that the airline violated the US ELCRA, USERRA, by not rehiring him promptly after he completed his tour of duty. Specifically, American Airlines waited more than 2 months before reinstating him to an equivalent position. Plaintiff pointed to scattered comments made by the airline employees in an effort to establish that he had been discriminated against. But the court held that while the comments did not serve to establish discrimination, simply because American Airlines took 2+ months to reinstate him following his return from service. The court said that that was a violation of the USERRA, and as a result, he had established his claim. The next case, I said something false. I told you that we were on the last case, but I'll just quickly say, check out this discovery issue case. If you are denied depositions, my colleagues from the opposite side of the bar here, if you're denied supervisor depositions, this case, the Court of Appeals for the Sixth Circuit said that the district court improperly denied the plaintiff's right to depose her supervisors and to see her supervisor's personnel files. So I thought a good case for you all to take a look at. Again, I want to thank Carolyn and Stephanie for putting the materials together. And I'd also like to take a moment to remember Tom Brady. As we all know, Tom was a well-respected leader in our section and a mentor to many. He passed in April of last year. He drafted the majority of these EEO materials every year since 1995. In fact, his work was included in these materials for any cases you find from January and February of 2020. Those were from Tom. He took great pride in educating us at Clark Hill during our monthly meetings and was proud of the EEO updates in his 25 years of educating us. Thank you.
Maria, thank you for your presentation, talking fast like you promised, and I could hear it in your voice at the end. I know the work that Tom provided to your firm and the work you guys did with him was special. So what I'd like to do now is do some more thank yous. So I'd really like to thank Amy, Kevin, Aaron, Jennifer, and Maria for their time today, their wonderful materials, everything that they put together. And we get to do one more big thank you to Fortz. Fortz has put this on for us today through Zoom. They've been behind the scenes back and forth with me all day and messages, and we've been figuring out lots of the tech issues and keeping people up to date. And when I called them and said, hey, we're doing this and we're putting it together and it's gonna be the first time for the section, can you guys help me out? Believe it or not, the first thing they said is yes, and the second thing they said is we'll do it for free. So we really, really appreciate them and their time. I've gotten a chance to work with some other people doing Zoom depositions, as I'm sure we've all learned. I'd love for you guys all to take a look at this video right now, and then as soon as it's done, we're going to go into our annual business meeting with Michelle Crockett and John Runyon, and stay on till 5 because we have a very, very special presentation for Dan Swanson. It's good to see all of you virtually, and I really hope to see you all in person again next year. Thank you.
Fortz Legal, we know it can be difficult to navigate depositions in a remote setting.
Can you see the exhibit now?
And like it or not, it's here to stay. That's why we crafted a unique exhibit workflow to make your remote deposition experience as seamless as possible.
Hello, how are you today?
Through our system, clients send us their exhibit files. We create an exhibit index and staff an exhibit technician to execute the workflow.
Hi, I'll be your exhibit technician today.
Part of the role of this technician is to display the requested exhibit through Zoom's share screen. Then they provide real-time courtesy copies to all participants by sending secure share links through the Zoom chat. You can schedule your short demo now to experience our exhibit workflow for yourself. We make the remote deposition process easy, and we're here to support you every step of the way.
Okay, hello everybody. So as Heidi indicated, it is now time for the business portion of our meeting. Before we begin though, I just want to thank Heidi again for all of her hard work. She put together a tremendous seminar. So Heidi, we owe you a debt of gratitude. Thank you so much. And I also want to just thank our speakers again. Your presentations were top notch. And we really appreciate all of the effort and time that you put into them. So with that, I'd like to call the 2021 annual meeting to order. The first thing on our agenda is approval of the council's December and January meeting minutes. Those meeting minutes are in the chat box. For those of you who care to review them, these minutes were actually sent to the council in advance of the meeting today. So I will ask if there are any corrections to the minutes. And if so, just please unmute yourself. Okay, hearing none, is there a motion to approve the minutes as submitted? One of the council members could make that motion, please.
I'll approve.
Thank you. Is there a second? Oh, come on, guys. Thank you, Aaron. Okay, all those in favor, please say aye.
Aye.
I'm going to assume that's a consensus.
Yeah.
All those opposed. Okay, the motion carries. The only other business we need to conduct is the election of officers and new council members. This year's nominating committee was appointed pursuant to Article 4, Section 1 of the section's bylaws, and the committee consisted of Jennifer Sabrin, Sharif Akil, and Niraj Ganatra. The committee did a fantastic job of identifying and recommending Maria Dwyer, Colleen Carroll, Ava Barber, and Sharif Akil as new council members. And the proposed officers of the council are Tad Ramaya as treasurer, Heidi Sharp as our secretary, Keith Brody as vice chair, and the great John Runyon as our new chair. Are there any nominations from the floor? If so, please unmute yourself. Okay, hearing none, in accordance with Article 4, Section 2 of the section's bylaws, is there a motion to approve the slate of new council members and officers as proposed by the nominating committee? I need one of the council members or someone to make that motion.
We have a motion in the chat.
Oh, awesome. Okay. Is there a second also in the chat?
Yep. There's a second from the chat from Rhonda. Yep, we got a couple of seconds in the chat, so we're good there.
Awesome. Awesome. Okay, keep it coming, because our bylaws mandate that by a show of hands, we approve this motion. So to comply with that mandate, I'm going to ask all section members to use the chat feature and simply type in yes or no. I'll give you a second or two to do that. Heidi's keeping tabs, thank goodness.
Kind of. I see lots of yeses coming in, so we'll save our chat for the minutes. So.
Okay.
Yep. They're still coming, so it's good news.
Okay. So it looks like the majority has voted to approve. That's what I'm getting.
And we see no no's.
Okay, awesome. So it's unanimous. So the motion passes. So congratulations to all our new members and to all of our new officers. At this point, I have the honor of officially passing the gavel, so to speak, to the esteemed John Runyon, who will thank our outgoing council members and then properly introduce our new members and our officers. But before I do that, I just want to take a quick moment to just thank the council, to thank the section for allowing me to serve as chair this year. It has been an honor to do so. I am looking forward to seeing all of the wonderful things that I know the council has planned for this year actually come to fruition. And the council sent me an amazing bouquet of flowers this morning that I received. It is amazing. I would hold it up, but I swear the vase is so heavy, I don't know that I'll be able to do it. But it's called A Touch of Spring, and it's perfect given the fact that we are in the dead of winter. So thank you all so very, very much for the beautiful bouquet of flowers. And again, for just allowing me to serve as your chair.
So Michelle, we've also have a plaque on the way to you. I know you haven't received it. The Postal Service is, it was mailed last week, but
It's not what it used to be.
It thanks you for your year of leadership of our section and our council in a most challenging time. And we all expressed it to you at our last council meeting, but let me, and on behalf of the entire council and the entire section, thank you for your good work over the past year.
Thank you. Thank you so much, everybody. So over to you, John. The floor is yours.
Thank you. And I also would like to thank the outgoing retiring members of the council, Adam Foreman and Erin Hopper Donahue and her assistant Madison and James Reed. So thanks to all of you. They've all served 2 terms on the council and they're not eligible, but we'll try to get them back after they're off the required number of years. So thank you. I don't think Adam's with us, but thank you both, Erin and James, for all of your work on behalf of the section. With that, before we get to the Distinguished Service Award, I just want to call your attention to a few activities that we have scheduled. As most of you probably know from emails, we have a new mentorship program this year, which is underway. If there's anyone that's interested in participating either as a mentee or mentor, just email me. We've started and we just had an orientation, but we're willing to take latecomers if anyone that's interested. The Labor and Employment Law Institute is going to be by Zoom this year, and that's going to be available with live stream sessions starting on April 15th and 16th. And we also have in the works a virtual platform training, preparing for your first Zoom arbitration. We have a group of arbitrators from the National Academy of Arbitrators that's put together a program, and that's tentatively scheduled right now for May 13th. Finally, I hope this isn't too optimistic, but we've had something in the past called Springboard. James helped us run that for a couple of years. We're going to maybe call it Spring Summer Board this year because we're not sure exactly when it's going to be, but hopefully that will be our first live in-person event. So watch for information regarding that program. With that, I'll turn it over to our new treasurer, Tad Ramaya, who will make some remarks about our Distinguished Service Award.
Thanks, John. Thanks everyone for joining us today and for being here. I know we're running a little bit behind, so I will be extremely brief. It is my honor and privilege to introduce my friend and mentor, Dan Swanson, for the Distinguished Service Award. We have a really cool video that we put together, pre-recorded for today. And that video is capped off with an introduction of Dan and a question and answer session between Dan and I, which we thought was kind of a cool, different thing to do for this year, given the circumstances. You get to kind of know him a little bit better if you don't already. And we hope you enjoy the video, and I hope to see you all in person soon. And so I guess without further ado, we can run the video that we had recorded for today for Dan.
This is Don Gazork, and I want to say that it's certainly an honor and a privilege to be asked to give some comments with regard to Dan Swanson and the honor that he's about to receive from the State Bar. We worked together. We became close and fast friends in the late 70s and early 80s. And in 1981, I left the firm and went out to another firm. And we were separated for a number of years. We joined up later again. But let me say this, that was a perfect time. It was an absolutely perfect time for an individual like Dan Swanson to be a lawyer, because it was something I think he had always had his mind on. It was something he was focused on. He grew up in the civil rights area of the 60s. He was active in those kinds of, I won't say riots, but the kinds of demonstrations that existed in the 60s when he was in Michigan in his undergrad and in law school. So that in 1978, when he was a lawyer, he could take advantage of those things. And I have to say it was a perfect time for someone with Dan's attributes to become a lawyer, because if you recall, 1981, Tucson was decided. And it opened up, along with the NLRA Civil Rights Act and Title VII and the ADA and Persons with Disabilities Civil Rights Act, the Handicappers Civil Rights Act. It opened up a whole new avenue for someone like Dan, who was focused on helping others and doing things for others and making the world a better place for other people. And he could devote a career to it, because all of a sudden labor and employment law became something much more than arguing collective bargaining agreements. So you could take it out to the people in the street, so to speak, and deal with them and help them on an individual basis.
Congratulations, Dad. The entire family is very proud of the accomplishment. This is very well deserved. I was playing golf. You actually weren't there, but one of my playing partners said, "Are you Dan Swanson's son?" I said, "Yep, I am Dan Swanson's son." And he said, "Well, are you Dan's a lawyer, right?" And I said, "Yep, he's a lawyer, employment lawyer at Summer Schwartz." Then I went to grab a club or something, and then the next words I heard out of the guy's mouth were "little guy," and I said, "Well, I wouldn't necessarily call him a little guy. He's smaller than I am, but I don't think he's a little guy." And the guy said, "No. He's not a little guy. I mean, he's a lawyer that fights for the little guy." And I said, "Yeah, he would love it if that's how he knew people thought of him."
Hello, everyone. I am honored to introduce Daniel Swanson for the 2021 Labor and Employment Law Section Distinguished Service Award. Over his 42-plus-year career, Dan has made significant and enduring contributions to the practice of labor and employment law. Dan has practiced in the area of employment law for virtually his entire career. Although he initially represented employers, over the past 25 years, his practice has evolved to a majority plaintiff side practice. Today, he is one of the most respected and successful plaintiff side employment lawyers in the section. A longtime member of the LELS section and council, Dan served as chair of the LELS council from 2014 to 2015. He has remained a valuable resource to the council even after his term has ended. Over his career, Dan has also chaired the Yoakum County Bar Association Labor and Employment Law Section. He served on the board of directors of the American Constitution Society, and he served on the Michigan Association for Justice Executive Board. A consummate professional, Dan has also served on the Thomas M. Cooley Law School Professionalism Advisory Committee. In addition to his service to the practice, Dan has served the broader community through his time as chairperson and member of the board of directors of Cass Community Social Services, a Detroit-based agency dedicated to providing food, housing, health services, and job programs. Dan has also served as an officer and member of the board of directors of Birmingham Country Club. Dan has received numerous accolades, including Michigan Lawyers Weekly Leaders in the Law, Best Lawyers in Employment Law, The Business Top Lawyer, Super Lawyers, AV Preeminent Lawyer from Martindale Hubble, and most recently, Law Dragon 500 Leading Plaintiff Employment Lawyers. Dan has also received a recognition for his pro bono service from the U.S. District Court for the Eastern District of Michigan. In 2019, Dan received the Michigan Defense Trial Council Respected Advocate Award, which honors a member of the plaintiff's bar with a history of successfully representing clients and adhering to the highest standards of ethics, mutual respect, and civility. Perhaps one of the most important ways that Dan has served the section is that he has been instrumental in mentoring and training several young lawyers who have gone on to become respected and productive members of the section in their own right. As one of Dan's mentees, I can personally speak to the fact that Dan invests significant time and effort in developing young attorneys and sets a concrete example of how to practice employment law in a competent, ethical, and professional manner. His peers in the section, both on the plaintiff and defense side, can attest to Dan's legal acumen and profession. Dan Swanson fulfills all of the qualifications for this high accolade. For that reason, it is my honor to introduce Dan Swanson for this award.
Great, thanks Tad for your kind words and introducing me, and I'm ready to answer the questions.
Okay. Well, first of all, since I guess this is the reason why we're here today, is what does receiving the Labor and Employment Law Section of the State Bar of Michigan Distinguished Service Award mean to you? What does that mean to you?
Well, it means a lot. And first, I just want to say to the Labor and Employment Law Council, I am really humbled and thrilled by your decision to award me the Distinguished Service Award. It means a lot to me. This award, as you probably all know, is meant to honor members of our section who throughout their career have demonstrated some really important qualities. They have made major contributions to the labor employment practice. These are people who are ethical, civil, and professional in how they practice law. They've advanced the development of labor and employment law. They've made a commitment to excellence. And finally, they're well recognized by the labor and employment law community. Wow. You know, the only thing left off that list of qualifications is the ability to walk on water, it seems like. And I got to tell you, I am really humbled because I look at the list of past recipients of this award, and I consider those men and women to be, you know, really giants in our profession. And I've had the privilege to know a number of them, and I'll just mention a few of them today. Folks like Professor Ted St. Antoine. He was my labor law professor at the University of Michigan. He's a great scholar, writer, speaker. He's one of the folks who, you know, inspired me to get into labor and employment law. And there are a number of other folks on that list. Joe Golden, Mike Pick, Kathy Bogus, John Ryan, all great plaintiffs and lawyers who, you know, really set an example for me in terms of being a successful plaintiff employment lawyer. There's a number of outstanding defense attorneys I've had the privilege of. Dave Calzone, Megan Norris, Tom Holland. You know, these are folks who received this award, who I have been adversaries in litigation in the courtroom where they fight like hell, but they've also taught me that when we get outside the courtroom, we can be friends and respected colleagues. So, you know, I consider the folks who've gotten this award in the past to be sort of like the all-star team of labor and employment lawyers, and it's really a thrill to be asked to join that team.
Well, what is some advice that you would give to young attorneys starting out today?
Well, Ted, I got to tell you, one of the best decisions I've made over the years is hiring yourself and many of your predecessors in terms of other young associates. Probably I've hired somewhere in excess of a half a dozen or more folks, and it's been really gratifying to work with and be a mentor to these young attorneys like yourself. And it's really been something that I've enjoyed. What advice do I have? Well, a couple things. First of all, I'd say set high professional and personal goals for yourself. You know, goals are like a destination and a roadmap. Without a destination, you will only travel aimlessly and in circles. Goals provide us with a destination to strive for through thick and thin. Second, don't give up. You're going to pass through in your career a lot of hills and valleys. The key is staying focused on the long game and looking not to the particular problem or whatever, and focus on the long game. You'll get through it. I think third, you've got to enjoy what you're doing. If it isn't fun, whether it's practicing law or staying within the labor and employment area, and you have an interest in something else, try it out. Do it. You know, practicing law is, we all know, very demanding of your time, your intellect, your emotions. You really have to be committed. So if you don't enjoy it, you've got to find the courage to figure out a new plan or career that you think you will enjoy, and then go do it.
Over the years, I've known you to be not only very committed professionally to your job, but also a very committed family man. I mean, you've always put your family first. You've always been there for them, and I've admired that about you. And now that I have a young family of my own with two small children, and my wife, who's also full-time practicing attorney. I know Leslie also had a full career in banking. What are your thoughts on maintaining a successful balance between family and the practice of law, which can be so demanding?
Well, that's a tough question. Earlier in our conversation, I said something about being able to walk on water, and I can't do it. Well, in this area, you know, I've tried hard over the years, and I will tell you as an example where, you know, sometimes it's hard to prioritize effectively between work and your family. Making money, becoming a partner, winning cases are all great. But, you know, there are some things that, you know, frankly, I think are more important. I recall my son, who's Mark, now 38 and practicing law. I missed his second birthday party because I was in Wayne County arguing a motion. And you said to me a few minutes ago, what are some things you might do over again differently? Well, that certainly would probably rise to that list, even if it's not, you know, something of great consequence in, you know, law, but it's in great consequence relative to your family sometimes. So you gotta set priorities. Secondly, you gotta listen to what your significant other and kids tell you, which is not always easy. And if you're never around the house, or when you are around the house, all you're doing is on your laptop or, you know, iPad or something, focused on doing work things while this noise is in the background, you're not listening. And you're not going to hear, you know, what you probably need to hear and should hear, and they'll benefit by, you know, listening to your significant other and your kids.
That's great advice, Dan. Thank you. And I want to thank you for, you know, doing this today. And I think this was a great sort of change in the format for the different times that we're living in. Whereas I think we got to know a little bit more about you than we otherwise would have. And I appreciate that. And thank you all so much for being here and being a part of the program and listening to what we had to say. And with that, I will say have a good rest of your month and your year, and hopefully we'll be doing this in person next year.
Let's all hope we're able to share a drink at the DAC at the midwinter meeting, and
Amen.
You know, enjoy a great banquet next year, and when we return to normal. Thanks, Ted.
Sounds good. Thanks, Dan. Bye.
Congratulations, Dan, and thank you all for attending, and let's hope we can get together real soon. Take care.
Well, congratulations.
Yeah.
That's quite a tribute. Can I come over there? Or is it...
I think so. I think it's over. Oh, wait a minute. Not yet. Hello, everyone. I guess I am going to have a chance to offer a few comments and to thank everyone for this award. First, I want to thank Tad, who's we've been working together for 10 years, and I really value him as a friend and partner, and appreciate his kind comments. My other old friend is Don Gazorik, who made a few comments here today. He's been my mentor, my partner, my friend since the first day I began practicing law 43 years ago. Hey, Don, thanks for your kind words, and you know, some of them were even actually true, I think. I also want to thank my family for putting up with me and supporting me through the years, and beginning with my beautiful wife, Leslie, my kids, Mark, who you saw, and thank you, Mark, for your kind words, and Heather, my daughter, and also those 6 grandchildren. Finally, I want to thank my assistant, Annette DeCoste, who's been with me through thick and thin for about 30 years. She's the best. Folks, this award is really very important to me, and I again want to thank the section and the council for selecting me to receive it. I'm both honored and humbled by it. When I think of this award, I think about a statement that Martin Luther King made shortly before his death in 1968. Reverend King said, "The arc of the moral universe is long, but it bends toward justice." Those words have inspired me as a lawyer in good and bad times. Those words continue to inspire me today. I consider it really a privilege to practice labor and employment law. As lawyers, all of us, in our own way, every day, we have an opportunity to contribute toward making for a more just society and country. As we leave here today, I urge everyone in these challenging times to remember Martin Luther King's words and to continue the good fight to further the cause of justice. Again, thank you, everyone. Thank all those in the video for your kind words. I wish you well, and I look forward to seeing everyone at that cocktail party at the DAC next year. Bye.